Appeal is dismissed. Sentence modified.
The appellant has to surrender. You just read that.
The appellant has to surrender not later than 15th of October.
The appeal is dismissed. The appellants have to surrender not later than 10th October. The appeal is allowed. The appeal is allowed. None appears dismissed. None appears dismissed.
Item number 7, my lord, this is appeal filed by the state. My lord, the sole issue before the Honorable Single Judge and before this Honorable Court, whether the period for granting of TBA to be counted from the date when the employee joined in an unaided institution or with effect from the date of the approval and the institution became aided one. This is the sole point involved here. Your Lordship can have a plan. I am filing a short date chart for your Lordship's convenience, my lord. My lord,
No.
not passed by the Honorable Single Judge.
No stay was granted here, sir.
No, stay is not there.
In that case, we'll just leave the question open because it's almost 10 years.
My lord, the
We leave
entire,
the question open, let it be decided in some other case. This is a single case.
no, my lord,
It won't constitute a precedent, we'll say.
so some persons have already intervened in this matter.
They are not here,
also,
sir, today.
because of this pendency of this writ appeal.
They are not here today.
No, they are not here.
Then let's leave it. Why invite them? If they have gone to sleep, let them sleep, sir. Why do you want to wake them up? You say, considering that this is a case of an individual respondent to whom relief has been granted by the learned single judge, and further considering that in the last 9 years, the impugned order of the learned single judge has not been stayed by this court. This court considers it appropriate to clarify that the impugned order of the learned single judge will not constitute a precedent, and that the question of law arising from the impugned order can be agitated in any other appropriate case.
Oblige your loss.
The appeal is disposed of.
My appearance may be noted, my lord. If it's opposite party. Matter has become
Infractuous dismissed.
Here also the main proceeding has already been disposed of, so therefore this is
Infractuous and dismissed. All right, sir.
fine. Obliged.
None appears dismissed.
11th, the matter has been settled.
Settled, infractuous, dismissed. None appears dismissed.
Item 13.
Same order.
Item number 14.
Same order.
List item 15.
Item 14, I am permitted to withdraw.
14 memo taken on record, dismissed as withdrawn. 15 dismissed. None appears.
Item number 16.
None appears dismissed.
Item number 17.
My lord, may it please your lordship. My lord, this writ application is directed against the CM order of the Honorable Single Judge dated 25/2/15, directing the to extend the compensation from 2.5 to 8 lakhs. That is the subject matter of case. And whether the Honorable Single Judge is justified in directing the
So there's no stay of the impugned order.
Pardon? I have seen, my lord.
There is no order. There is no order of stay.
My lord, it is not yet finalized because the writ appeal is pending. No order. I not yet admitted.
So why do you want us to now interfere after 7 years? Have you, implemented the impugned order?
Because it is not yet paid.
That is so on your, you've given yourself a stay basically.
My lord. No, my lord.
Of course.
Because matter is
You
pending,
have-
my lord.
So mere pendency of matter means it is stayed.
My lord,
You tell us if there is no stay of the order,
yes, my lord.
it means automatic stay.
My lord, we have challenged that order
So,
and not yet listed, my lord.
and,
And today it is listed only.
so it's automatic stay.
No, my lord. That's not automatic state.
Have you implemented, sir?
Because we have a point.
Have you implemented?
Because we have some point to go or before.
All that is fine. Have you implemented?
Not yet implemented.
First implemented.
Then
First implemented.
Then it is infructuous. Then it will be infructuous.
Yes. We'll say once you deposit, pay the money, it will be subject to the outcome of the writ appeal.
Yes, my lord. Yes.
When will you pay?
The lords will grant at least 2 weeks time.
Counsel for the appellant insists on arguing the present appeal, despite the fact that the impugned order of the learned single judge has not been stayed for the last 7 years. We'll stop. The compensation amount. This is a death, is it?
No. It is a land acquire. There's some installation in the land of the opposite party.
The compensation amount for the land acquired has been increased
From 2.5
from
lakhs
rupees
to 8 lakhs.
2.5 lakhs to rupees 8 lakhs. Together with interest at 8% per annum. We'll stop. Counsel for the appellant states that the appellant will deposit the enhanced sum together with the interest up to the date of deposit in this court on or before 17th October 2022. Subject to compliance with the above assurance. List on 18th October.
Deposit here, my lord.
Yes, please.
Yes.
Weekly list item number 18.
And for the opposite party workman.
None appears dismissed.
Weekly list item 19.
My lord, may I pay urgent copy? But if I
Yes. I'll check.
Item number 19.
Item 20 minutes.
None appears dismissed.
Item number 20.
20 minutes. May I please your lordship. My lord, in this case, notice was issued on limitation.
What is the delay, sir?
Only 20 days.
All right. Tell us what the matter is.
Only 20 days delay.
Tell us what the matter is about.
Matter is about the order of the Lawrence single judge of this court has been challenged in this writ appeal. My lord, the matter is that the petitioner was serving as an Anganwadi worker. She has not submitted her resignation. Her father-in-law has obtained and husband. They have obtained a signature on the blank paper and submitted it before the sub-collector judge.
All right.
And as the sub-collector accepted the resignation.
All right.
But she had the intention to serve.
Very good, sir. Very good.
So he objected the matter before the collector. And the collector also directed the sub-collector to consider her case.
Correct.
But the sub-collector remained adamant and did not allow her to join.
Very good.
As a result of which she approached this honorable court. This honorable, the honorable single judge held that it involves a disputed question of fact. So for remedial measure, you approach appropriate court. That means civil court for us.
Yes, sir. Tell us what is wrong with the orders?
Ground is that I have not submitted the resignation letter.
All right.
My signature has been fraudulently taken.
All right.
I have the intention to serve.
All right.
So your lordship may kindly direct the authority to observe me anywhere. I'm
All right.
destitute lady.
All right. This appeal is directed against the order dated 2nd March 2015. Per se, you delay is condoned. This appeal is directed against an order dated 2nd March 2015, passed by the learned single judge, dismissing the appellant's writ petition civil 9902 of 2013. The writ petition was filed challenging an order passed by the sub-collector Jashpur, rejecting the petitioner's representation that the resignation letter submitted by her from the post of Anganwadi worker at the Lakshmi Nagar 5 Anganwadi Center on 7th November 2012 should not be accepted, since according to the appellant, her signatures were forcibly taken on a blank paper by her in-laws. Paragraph. The learned single judge has rightly observed that whether or not the resignation letter was voluntarily submitted by the petitioner is a disputed question of fact which we adjudicated. Consequently, the order of the sub-collector was not interfered with. And cannot be adjudicated in a writ petition, full stop. Consequently, the order of the sub-collector was not interfered with. Counsel to the appellant again maintains that it is due to the pressure and harassment of her in-laws, the appellant was forced to submit a resignation letter, which was obtained mischievously. Paragraph. As observed by the learned single judge, this being a highly disputed question of fact cannot possibly be adjudicated in writ proceedings under Article 226 of the Constitution. Stop. The court therefore finds no ground to interfere with the impugned order of the learned single judge. The appeal is dismissed.
Weekly list item 21.
Lordship 21-22 is infructuous.
Infructuous dismissed.
Weekly list item 23.
None appears dismissed.
Item
And for
number,
the respondent.
item number 24.
States.
My lord, yes, my lord.
Okay, 24.
24.
My lord, may kindly pass over for
All right, pass.
Item number 25.
Food corporation. Food corporation.
None
23
appears
food
dismissed.
corporation.
Item number 26.
Same order.
Item number 27.
Infructuous, your lordship. Infructuous dismissed.
Item number 28.
I am for the respondent number 3, my lord.
None appears dismissed.
Item number 29.
My lord, on behalf of Mr. Sadaship Patra, no instruction.
No instructions dismissed.
Weekly list item 30.
I may plead your lordship.
I am for the respondent number 4.
I'm on God sure. I have been limited to prayer lordship down to page 10 of my writ application. Page 10 of my writ application. The order passed by this honorable court. The writ petition has been filed by the opposed petitioner challenging the order dated such and such passed by the sub-collector Puri disposing her appeal, which was filed challenging selection of organic helper for Gosia Anganwadi Worker Center for CDPO Astaranga. Considering the submission made by and perusing the impugned order, I find that the appellant authority has for the same impugned order directed a fresh selection of the Anganwadi worker after fresh selection of opposite has been selected. Therefore, I do not. Before that, my lord, I come to page 13. Page 13, my lord, 1-3. The interim order was passed on 8/11/2013, and without counter, without any opposition, now the that order has been vacated and case is disposed of. Lastly, can you turn to page 13, my lord? Page 13, there is a direction not to conduct any fresh selection. While matters stood thus and no counter filed, nothing said, my lord, it is disposed of since the sub-collector has decided a fresh selection. It is disposed of.
You want this matter to go back to the single judge?
My lord, should be hard on merit.
All right. Who's appearing?
I am for the respondent number 4, my lord.
All right. Do you have anything to say, sir?
My lord, the page number 13 shows that order dated 8/11/2013, there is direction not to hold any fresh Mahila Sabha. But on which date the Mahila Sabha has been conducted, that my learned senior has not mentioned in the writ appeal. Whether that Mahila Sabha held prior to the order passed by this honorable court or subsequent or after passing of this order, that writ appeal is clear, totally silent, my lord.
No, the impugned order itself notes that there is a fresh selection held, sir. So obviously it has to be before the order. Just read the impugned order.
My lord, that is order dated 27/4/2015. That is the
Correct.
final order passed by this honorable
That's
court.
what has been challenged here,
But
sir.
the stay order was passed on dated 8/11/2013.
Correct.
But whether the fresh Mahila Sabha was held prior to 8/11/2013, that
No,
the
must
order.
be after, sir.
Actually,
Just see
the
the
challenger-
order.
But the writ
Obviously
appeal
it's
is
after. That's
completely
how
silent, my lord.
para 3 says that. You see, the present appeal is directed against an order dated 27th April 2015 passed by the learned single judge, dismissing the appellant's writ petition civil 23366 of 2013, whereby the appellant had challenged the selection of respondent before herein as Anganwadi helper. For the Gosinga Anganwadi Center under the CDPO Astaranga. Paragraph. The perusal of the impugned order. This court has heard the submissions of Mr. Kaliprashan Musnar, senior counsel for the appellant. And what's your name, sir?
Sambit Patnaik.
Mr. Sambit Patnaik, learned counsel appearing for respondent before. A perusal of the impugned order reveals that no reasons have been given by the learned single judge for rejecting the writ petition, except noting that pursuant to the direction issued by the appellate authority for a fresh selection, respondent before had been selected. Stop. In other words, the merits of the writ petition has not been discussed at all. Stop. Considering that this was the first level of challenge, it was necessary for the learned single judge to have examined the merits of the writ petition and passed an order after dealing with the contentions of the parties. Stop. On that short ground, the impugned order dated 27th April 2015 is hereby set aside. And writ petition civil 23366 of 2013 is restored to the file of the learned single judge in the roster bench. It will be listed on 5th December 2022. In the meanwhile, if not already filed, are the pleadings complete in the writ petition?
Yes, my lord. No counter in the writ application.
Yeah, the
No objection any form.
The counter affidavit of all the parties should be filed positively on or before 30th November 2022 in the writ petition. And rejoined that too before 5th December 2022. No further time will be granted for that purpose. The learned single judge is requested to dispose of the writ petition as expeditiously as possible. The appeal is disposed of in the above terms.
Highly obliged.
Obliged.
My lord, I may be excuse me, lord. I have item 18. I have rushing. I could
Sir,
not
we
reach.
are,
Item 18.
we are now in item 31, sir.
My lord.
Can you take a note today?
We don't know, sir. We don't know. All right.
Item number 31.
None appears dismissed.
Item number 32.
None appears dismissed.
Item number 33.
None appears dismissed.
Item number 34.
Item 34 is the state appeal. It's an interim order against an interim order. But finally, the restriction was disposed of 16
Yeah,
July 2000.
considering that this is writ appeal is against an interim order and the writ petition itself has been disposed of, the appeal has become infraction, is disposed of as such.
Weekly list item 35.
None appears dismissed.
Sir, we came here for watching the judgment at Annex 6, passed by Lawrence Single Judge in WPC number 8445 of 2011. This is a case of Anganwadi selection of Anganwadi worker, illegal selection of Anganwadi worker. OP number 3 secured less mark than the petitioner. Violation of principle of natural justice and against the mandate of law.
That's it, madam. All right. The present appeal is directed and order dated 13th May 2015, passed by the learned single judge, dismissing the appellant's writ petition civil 8445/2011, challenge the selection of respondent 3 as Anganwadi worker at the Talasari 2 center in Cuttack. Full stop. It appears that the present petitioner was a resident not of Talasari 2, but Talasari 1 Anganwadi Center. Full stop. The ADM had called for the records to examine the contention of the appellant. The land was a joint property situated in the Talasari 2 Anganwadi Center area. So a report was called for from the CDPO by the ADM. The report submitted by the CDPO was that the appellant and her husband were residing in the house of her father-in-law in another land situated in Upar Sahi, New village Talasari, which comes under Talasari 1 Anganwadi Center area. That is outside Talasari 2 Anganwadi Center area. Stop. The learned single judge has again examined the records, which were examined by the ADM. Stop. The learned single judge has correctly observed that in a writ jurisdiction, concurrent findings of fact based on the inquiry report of the CDPO cannot be interfered with. Full stop. Paragraph: having heard learned counsel for the appellant, the court is not persuaded that the learned single judge has committed an error in declining to interfere with the order of the ADM, which has accepted the inquiry report of the CDPO. Accordingly, there is no merit in this appeal and it is dismissed as such.
Item 36.
Item 36, your lordship, infractuous, your lordship.
Infractuous dismissed.
Item number 37.
In item 37, the order of additional decision has been challenged before the honorable single judge. Against that, I have preferred writ appeal. Or if it is not maintainable, your lordship.
All right. On the ground of non-maintainability, counsel for the appellant seeks leave to withdraw the appeal with liberty to seek other appropriate remedies as may be available to the appellant in accordance with law.
Item
Post office withdrawn with liberty spirit.
38.
I am for the opposite party.
None appears for the appellant. Dismissed for non-prosecution.
Item number 39.
39, no instruction.
No instructions. Dismissed.
Item number 40.
40, my lord, I am filing the. So this appeal is filed against the order of the honorable single judge, where that the honorable, that is
Anyway,
annexed.
delay is condoned. Come to the merits, sir.
My lord. The petitioner was neither appointed on a for the certificate. He was appointed by virtue of the second advertisement being is meritorious among all the candidates. And he was not in the party in the appeal in the previous year. And without filing appeal, in the petition was allowed, and the petitioner was directed to dismiss from the service.
What is your ground of challenge to the impugned order of the learned single judge?
My lord. That the petitioner, the appellant was neither appointed on for the certificate. The judgment was based on the for the certificate. Neither the opposite party nor the any petitioner, they have raised a single question regarding the forgery certificate of the appellant. But the honorable court has decided that he was appointed on for the certificate.
Where is the finding, sir? Which paragraph?
Page 3, my lord.
Paragraph.
Page 30, internal page, the judgment.
Sir, just give us the paragraph number of the judgment.
That is one first paragraph, my lord.
First paragraph. Finding is in the first paragraph.
No, that's a grievance.
Sir, give us the finding in the impugned order of the learned single judge. And please refer to the paragraph number.
There is no paragraph, my lord.
Sir, the impugned order, that's at which page, sir, in your paper book?
My lord, that is starts from the page 30, 29, my lord.
29.
29. Page 33.
Page 33.
I am placing the second paragraph. The grievance of the petitioner is that since the selection or engagement of opposite party number 7, opposite party number 7 is the appellant, has been struck down on the ground of using further educational certificates. Then the direction issuance of a fresh selection process is highly unreasonable, and that has a prejudice in the interest of the petitioner because of if the genuineness of the educational certificate would have been decided at the time of scrutiny, the document of the candidature of opposite party number 7 would have been cancelled.
What do you have to say, sir?
Petitioner has nobody has raised that I have a using for.
Nobody is raised. Come to page 35. Come to page 35.
My lord. Had the parties at a length and
no, the undisputed fact.
The undisputed fact that the case is that pursuant to the one advertisement, the petitioner as well as the opposite party number 7 had participated, and the opposite party number 7 at the time the first instance was selected. But subsequently it was found that she was selected on basis of further educational certificate. But in
read on, sir.
Read on. First advertisement.
Continue reading. Continue reading.
My lord. At the first instance and selected, but subsequently it was found that she was selected on the basis of a further educational certificate, which has been objected by the petitioner, and therefore the engagement order of opposite party number 7 has been cancelled.
Yes.
But in the first selection, advertisement.
This was objected, therefore it was cancelled, sir.
No. I have not participated, even if I have not participated in the first selection, and I have not used any for certificate.
Yes.
Neither nor the petitioner has raised that I have used the for certificate.
Yes, they have objected, sir. That's how it has been cancelled. Yes.
That the petitioner who being stood second position in the merit list
Yes.
would have been selected on the ground of forgery by the opposite party number 7.
All right.
It is the duty of the authority who issued advertisement to verify the certificate from its original at the time of scrutiny of the application forms, so that the genuineness of the certificate and the genuineness of the certificate can be, the candidate can be assessed at the threshold of a consideration of the candidature. The authorities have entertained the application form of the candidates, including the opposite party number 7. And she was selected, but subsequently it was found she was selected on basis of forged educational certificate. Only the judgment is based on the forged certificate, whereas not a single question raised by the CDPO, nor any petitioner, nor any opposite party that I have used the forged certificate. But the Honorable Judge has decided that I have used the forged certificate and participated. This is the sole.
What does you say?
That's here. There were two rounds of selection for the same Anganwadi post. In the first round of selection, the opposite party number 7 was found to have been selected on the basis of a forged certificate.
That is the present appellant.
That is the present appellant.
No. He says nobody objected. How did you find out that she used a forged certificate?
My lords, the first round, my lords may kindly, the finding has been on the basis of some other point, if my lords may give me some. Thereafter, my lords, once the CDPO said that this has been found, there has been a forged certificate and there's an issue with regard to that, they cancelled that process itself and issued selection. In the second round, the appellant scored the highest marks and the appellant was selected. This was objected to by the petitioner in the writ petition, saying that since she was number 2 in the first round, so if the appellant's selection goes, then she should have got. And the authorities did not have any power to issue a fresh round of selection. And the single judge has said that the authority should have seen that the second person should have been selected rather than going for the first round.
But is it a fact that she used a forged certificate? Because that's what he's contesting. He says nobody objected to certificate being forged.
Yes, that is. But the single judge has found that the certificate has been forged. So, irrespective of whether there was
no. What's the factual
CDPO
position? He's in appeal here. He's challenging it. Please, was it forged or not?
Whether it's forged or not, the CDPO has found that it is forged.
Where do you get that?
No. Let's may find page 35. The last paragraph, the unnumbered documents. The authorities have entertained the application forms of all the candidates, including the opposite party number 7, who's the appellant here, and she was selected. But subsequently, it was found she was selected on the basis of forged educational certificate, and therefore it was cancelled. And thereafter, if I may read, the question.
That's okay. The only question is, was there any objection to her using a forged educational certificate?
No, admittedly there was no objection.
No, he's repeatedly contending that nobody objected.
Yes. So this has been, if I may say, a suo motu finding of the authorities. Therefore, they went for another round of selection, whereas the single judge says that they shouldn't have gone for the second round selection and should have selected the second person in the merit list, who is the petitioner in the writ petition.
In fact, page 37, there was a stay order.
Please, the stay order was for 3 weeks, and the stay order was on 9th of May 2011, and the person was selected. Let me say 34. The person was selected on 31st of May 2011. So
but the stay was still pending.
Was 3 weeks would be 21 days or 30th. My respectful submission. So 31st. So on 31st there was no.
Yes.
So it's just cutting it too close, but so the issue, if I may say, is that whether the authorities had any power to cancel the first round of selection and go for a fresh selection.
That is
And
pursuant to
whereas
the
the
Annex 2,
Anganwadi
my lord.
workers are selected through a scheme. So whereas the employer has, once the employer sees that there has been some issue with regard to the first round of selection, it's well within its powers to go for fresh selection. And Miller, it's not that the petitioner was barred from.
You have not come in writ appeal, sir. He
No,
has come in writ appeal. You have accepted the order of the single judge.
Yes, sir.
And the single judge says there was no justification for going in for a fresh selection.
This Sarojini Panda has been presently working. That is one. 2015.
Parida, Sarojini Parida is still okay.
Yes, that is what that has been mentioned, Millard, in the cause list, in the title, Millard.
That
At
may
present working at Anganwadi Center.
No, that at present could be anything. Just borrowing the
2015.
Yeah, there's no stay here, so
There's no
obviously.
stay. There's no stay.
You said this appeal is directed against an order dated 24th April 2015 passed by the learned single judge, allowing writ petition civil 15423 of 2011 filed by respond before hearing, who had filed full stop in the said writ petition. Respondent 4 had challenged the selection of the present appellant as Anganwadi worker in the Sahada 2 Anganwadi Center. Paragraph. The question before the learned single judge was whether the authorities were justified in cancelling the entire selection held in the first instance, in which it was found the present appellant had utilized a forged educational certificate. Full stop. The learned single judge noted that respondent before hearing was second in the order of merit, and the appellant was the first. And if the appellant's education certificate was found to be forged, then automatically the post must have been offered to respond before hearing. In other words, it was held that there was no justification for a fresh selection once it was plain that the appellant had used a forged educational certificate. Full stop. On that ground, the learned single judge has set aside the decision of the authority to go in for a fresh selection. Paragraph. Counsel of the appellant contended that there was no objection from any quarter to the certificate used by the appellant while participating in the first round of selection. Full stop. This contention does not appear to be correct. It is a perusal of the impugned order reveals that it is a CDPO who, when checking the documents submitted by the candidates, noted that the appellant had been selected on the basis of a forged educational certificate. Full stop. The impugned order, in fact, in the impugned order, the learned single judge has in fact noted that her selection on the basis of such forged educational certificate was indeed objected to by respondent before hearing. Full stop. Once it was clear that the certificate used by the appellant was a forged one, there was no question of requiring, allowing her to participate in a fresh selection by ordering a fresh selection. Stop. Having heard learned counsel of the parties, the court is not persuaded that the learned single judge is committed an error in declining to, in setting aside the order of the authorities for a fresh selection. Full stop. There is no merit in this appeal and it is dismissed as such.
Fresh selection was
We will-
IA to be the reason stated the IA is allowed.
Item number 41.
My lord, the phrase selection was a portions to the annexure 2, that is the appellate order.
All right.
In portions to the direction
None
of
appears
appellate-
dismissal, not prosecution. Right.
Item 42.
Item 42, my lord, it became infructuous.
Sorry,
Item 42, it became infructuous.
infractor is dismissed. All right.
Item number 43.
It will also no instruction.
No instructions dismissed.
Item number 44.
Because 44 has become infructuous.
Infractor is dismissed. Contribution is disposed of.
Item 45.
May I please, your lords? My lords, this, in this writ appeal, my lords, the impugned order is annexure 1 stain, my lord. The order dated 11/3/2015 passed by the honorable single judge is under challenge. And the case is, my lord, respondent number 1.
What's the explanation for the delay, sir?
Delay, there is delay, my lord. There is a delay.
Not properly explained.
Yes.
So MC 670 of 2015, the delay of 122 days has not been properly explained. Consequently, the court is not inclined to condone the delay. The application is dismissed. Consequently, the appeal is dismissed.
Second one is also.
Both, yes, same.
Correct.
Also, in first case, I am appearing for respondents.
Or
Item number
Second case
46.
also, I am appearing for respondents, both the cases.
Item number 46.
46. May I please, Lord?
come to the mic, sir.
Sir.
Mike.
Sorry. May I please, your lordship, Lord? This writ appeal is arising out of the judgment passed by the London single judge, Lord, dated 13/7/2015. The crux of the matter, my lord, that without going into the brief details, my lord, the appellant has approached to this honorable court, who was a proceeding was initiated against him on the ground that from 2093 to 1993 to 1998, while he was working as a agent, clerk, my lord, he was in prefixing the ledger, my lord, he was gaining the benefit. An allegation was leveled against him by one Sajidananda Sahu, one of the agent, my lord, on the basis of the which the proceeding initiated, my lord. Thereafter, my lord, the charge sheet was framed, charge sheet was filed, prosecution proceeded the case. The defense, he took 6 witnesses, my lord, out of 5 denied the allegation, and the sole contention of the appellant is, my lord, that the principle of natural justice has been grossly violated in view of the fact, my lord, the authorities, without bringing to the relevant complainant, my lord, they proceeded only on relying upon the documents and the signatures, and only on basing upon the preponderance of probabilities, without beyond reasonable doubt, the case was established. The punishment was imposed, my lord. 6 installment increments were stopped, and the petitioner did not prefer any appeal, my lord, before the appellate authority. Thereafter, one enhancement order was passed by the appropriate authority, my lord. That challenging that enhancement order, my lord, from removal service, that the petitioner appellant approached to this honorable court. This honorable court interfered and stayed the impugned order, and finally directed that as per the provision of the Life Insurance Corporation of India, you preferred a memorial before the chairman, my lord. He preferred the memorial, my lord. In memorial, my lord, the chairman, my lord, disposed on the ground that the employee cannot dictate as to how the prosecution will proceed. After that, my lord, the writ application was filed. Writ application was challenged. Writ application, in the writ application, the Honorable High Court, my lord, on the judgment of the P. Gunsakar case, my lord, dismissed the writ application,
stating in that the petitioner is involved in the financial offense. Therefore, the petitioner does not deserve any consideration. Without going into the aspect, the two aspects, my lord, I used to bring your lordship's kind attention only, my lord, the two aspects, my lord, without speaking anything more, my lord, that when a case is has to be established, my lord, it has to be established as per the Constitution of India, my lord, it has to be established with full proof, my lord, that when a punishment of disproportionate or removal from service, a punishment which is quite disproportionate, is who is removed, at least has to be proved beyond all reasonable doubt. Here is a case, they have not proved the beyond reasonable doubt.
Where's question of beyond reasonable doubt? This is not a criminal proceeding, sir.
Civil
disciplinary proceedings, it's only preponderance of probabilities. This is not a criminal proceeding, sir.
That, my lord, I don't want to contradict your lordship's opinion, my lord. I cannot say with your lordship's experience and yet.
Not for experience.
Only
Show us
thing,
the case law, sir. This is not about our experience. It's about the law. Kind show us the law which says in disciplinary proceedings, the standard of proof is beyond reasonable doubt.
That, my lord, the Article 309, my lord, your lordship, the prefixation of the figures in the commission ledger, my lord, for 5 years, and he was doing alone. He was doing alone and others were verifying and checking authorities were there. This aspect has also not been taken into consideration.
You have no answer to the questions. The question that was asked to you, you have no answer, sir.
My lord, I have only averred in the lordship and a glance, my lord, that in Tyagarajan case and in Haridilal case, my lord, I have averred in page 23, my lord, that I have emphasized on the ground for satisfaction of your lordship that at least the principle of sufficiency of evidence has to be established.
That's different. Now you have come to a different point. All right. Yes.
And my humble submission, my lord, the learned single judge rejected the application relying upon the judgment of the B. Aluwala case and P. Gunasekar case, my lord, which are not applicable to the present case. Because of the case authorities have not established the case against the petitioner fully, my lord. That is my humble submission.
Yes. Who's for the other side? Who's for the opposite side, sir?
The first time this matter.
Okay, so there's nothing in this, sir. You see, the challenge in the present appeal is to a judgment dated 13 July 2015 passed by the learned single judge, dismissing the appellant's writ petition civil 3930 of 2004, whereby the appellant had challenged the order imposing the punishment of removal from service passed by the opposite party, life insurance, opposite party oblique respondent herein, Life Insurance Corporation of India, bracket LIC, pursuant to disciplinary inquiry. Paragraph. The background facts are that while he was working as assistant at the Pulwani branch office under the Berhampur divisional office of the LIC, a department proceeding was initiated against the appellant for certain irregularities. Initially, on the inquiry officer taking a report holding the charges against the appellant to be proved, the disciplinary authority, bracket DA, imposed the punishment of reduction in basic pay by 6 stages in terms of regulation 39, bracket 1, bracket small d of the LIC of India, bracket staff, regulations 1960, bracket regulations, bracket. A show cause notice was then issued to the appellant by the DA in exercise of regulation 48, bracket 2. Full stop. However, while considering the reply of the appellant to the SCN, an enhanced punishment of service was passed. Full stop. The charge against the appellant was that he had committed serious financial irregularity by prefixing 1 or 2 digits in the agent's register of commission paid to the agents and bonus commission bills of agents. Full stop. The financial loss caused to the LSC was to the tune of rupees 346,200. Full stop. The appellant accepted the handwriting and signatures on the concerned ledger. Full stop. On the basis of the handwriting identification by the appellant himself, the EO concluded that the charge had been proved. Paragraph. After considering the reply of the appellant to the second show cause notice, at the initial stage, the penalty of reduction of basic pay by 6 stages was imposed. Paragraph. The reviewing authority exercised the power under Regulation 48(2) of the regulation and came to the conclusion that the punishment awarded was not in consonance with the gravity of the charge. Full stop. Accordingly, the second show cause notice was issued to the appellant, asking to explain why the penalty of removal from service should not be imposed. Full stop. The appellant then approached this court challenging the order of removal of service passed by the reviewing authority. Full stop. That writ petition, Civil 3305/2002, was disposed of, granting liberty to the appellant to prefer a memorial to the chairman, LIC. Full stop. After the chairman rejected the appeal, the writ petition, Civil 3930/2004, was filed, in which the impugned order has been passed. Full stop. The only issue before the learned single judge concerned the proportionality of the punishment imposed. Also, the learned single judge has relied on the decision of the Supreme Court in Union of India versus P. Gunashekaran, AIR 2015 SC 455, and conclude that given the gravity of the charge for which the appellant has been found guilty, the punishment awarded could not be said to be disproportionate. Paragraph. The learned single judge has noticed that the chairman had passed a very conscious and detailed order after discussing every aspect of the matter. Full stop. Since the charge related to the integrity of an employee, the punishment was considered appropriate. The punishment awarded was considered appropriate. Full stop. Having heard learned counsel for the appellant and having perused the impugned order of the learned single judge in light of the materials placed on record, the court is unable to come to a different view in the matter. Full stop. An employee who is found guilty of financial activities loses the confidence of the employer, and therefore his continuation in service becomes vulnerable. Full stop. As rightly pointed out by the learned single judge, this is an issue of integrity of the employee. This is an issue touching on the integrity of the employee. And with clear proof of lack of such integrity, it cannot be said that the punishment of removal from service was disproportionate. No grounds have been made out for interference with the impugn order of the London single judge. The appeal is dismissed.
Weekly list item 47.
None appeal is dismissed.
Item number 48.
48 Miller, infructuous matter is
Infructuous dismissed.
Item number 49.
Infructuous dismissed.
Item number 50.
None appeal is dismissed.
Item 51.
With great humility, Your Lordship, in item 51, I have missed the list. Maybe take it up tomorrow. Let me on board, Your Lordship. I'll place the matter tomorrow. I've missed the list.
At the request of counsel for the appellant, list tomorrow. All right.
Weekly list item 52.
Item 52, my Lordship, kindly see the last order dated, order number 3, 21 and 2015. On that date, my Lordship, while issuing notice in the matter, there's an interim order with regard to if the answer scripts by now have not been destroyed, the same may not be destroyed till next date. My learned senior is appearing for the university. Let him take instruction. If the scripts are still there with them, preserved with them, then
I'm going to take instruction in the matter.
Mahapatra appearing for the university seeks time for instructions on whether the answer sheets have been destroyed. At his request, list on 16th November.
Great. Weekly list item 53.
Delay. Receiver release.
Delay notice was directed to be issued.
169 days. The delay of 169 days has not been obtained. Consequently, MC 717 of 2015 is dismissed. As a result, writ appeal is dismissed.
Item 54.
28 days delays, no.
Delays how much?
The employees of the Odisha Electrification.
Delay control. Yes. What is the matter about, sir?
Matter about not the petitioner applied for VRS, and VRS was accepted, my lordship, with a retrospective effect. That petitioners have worked till VRS was received, allowed. For this period, the payment has not been made. That is the retrospective is illegal, and they have worked and the salary has not been allowed. On the self-same issue, this Honorable Court has also decided in a case 2013, and against this organization also, the direct payment. That was not considered by the lower court. No, sorry, honorable single judge.
No, but you are aware that if at all it is accepted, to be accepted from 30th April.
But I have the petitioners have worked.
No, but you applied for VRS knowing that whenever VRS is accepted, it will be from a back date.
Backdate, but retrospective,
you made
illegal.
That, it's not unknown to you, sir.
No, that's correct. But since the petitioner have worked, the payment should be made. That is the case, and the retrospective is illegal. And on the self-same issue, that has been decided and directed for payment to some of the employees.
Let's see.
And this case relied upon that was not considered. The 2013 volume 2 OLA page 451. That was there on the application under NS 3 at 4/3/2004. That was quashed and directed for payment fellow. This is the at page 8. So the make it very clear that petitioners have worked and are entitled to the same. And they're
Where are you reading, sir?
Para 8. Sorry, my lord.
It's a single judge judgment or division bench. What is it?
Division bench. That was relied upon, that was not considered by the Lord single judge.
Let's see that. Is it also lift irrigation corporation?
Yes, ma'am. And this is also one in the year of 2005 also, some of the employees.
Who's for the respondent? Is it coming for the first time?
No, he was here for September month. He appeared in the read.
Notice is not gone. You see, counsel for the appellant relies on the judgment of this court, of the division bench of this court in Sri Ashok Kumar Krushti, the State of Orissa, 2013, 3 OLR 451, to urge that. Is it Ashok Kumar Krushti? Which judgment, sir?
State, my lord, 451.
No, it's something about regularization. It's not about VRS acceptance.
Regulation and the VRS, both, my lord.
No. You told me it's identical, please.
Yes, my lord, identical.
No.
I'm showing
this is about some regularization.
Para 8, my lord. Regularize, they have considered, and simultaneously this case has been considered, my lords. And para 8. This being the position, we are not inclined to accept to the prayer of the petitioner to direct the opener to dispense with the service of the petitioners and to pass any order of their continuance. So far as the payment of the concern to the petitioners is concerned, same shall be paid by the OP corporation. So claim of the petitioner, their arrear salary since April 2007, we make it.
That's very different, sir. That's very different. Arrears of salary is different. Yes, that has nothing to do with this.
So the litigation and the regular.
No, but the issue is different. It's not the same issue. So counsel for the appellant relies on that decision, which I give you citation, to say that it covers the case on hand as well. The court is unable to agree. Said decision dealt with the issue of regularization of workmen, of the worker, and the paragraph referred to by the learned counsel for the appellant talks of arrears of salary for the period of work done. Work performed, full stop. However, in the present case, as pointed out by the learned single judge, the appellant knowingly applied for the voluntary retirement from service, bracket VRS, aware that once it is accepted, it would relate back to 30th April 2003. Full stop. Consequently, the prayer for the appellant that he should be paid arrears of salary up to the date of actual acceptance of the VRS, that is 20th May 2004, was without merit and has been rightly rejected by the learned single judge. Consequently, the court finds no grounds to interfere. The appeal is dismissed.
Weekly list item 55.
55, no instruction.
No instructions dismissed.
Weekly list item 56.
Memos taken on record. Infractuous.
Weekly list item 57.
Lordship, I'm appearing through VC. No instructions.
No instructions dismissed. Yes.
Weekly list item 58.
None appears dismissed.
Weekly list item 59.
None appears dismissed.
Weekly list item 60.
May I please, Your Lordship? Well, this is against an order of the Honorable Single Judge, dismissing the writ petition on the ground of delay.
Petitioners approached the court more than 19 years after passing the impugned order.
Well, against the appellate order.
Yes.
Thereafter, I preferred a memorial before the chairman.
That's okay. That's okay, sir.
60. That was rejected in 2008. Then I approached in a writ petition.
So the order, you went to the chairman against an order of 1989.
Yes, that was rejected in 2008.
No, it's okay.
Whereafter
When did you go to the chairman against that order?
2006.
And the either way, sir.
And the chairman.
So the removal order was passed on 10th November 1989, and the appellant chose to file a memorial before the chairman of the Lift Irrigation Corporation.
No, OSRTC.
Of the OSRTC only in 2006. That is 17 years after the order was passed. That itself was barred by laches. So after the chairman dismissed his representation, the writ petition civil 8971 of 2008 was filed, which has been rejected by the single on 22nd by the impugned order dated 22nd September 2015, again on the ground of delay. Paragraph. Indeed, there is no valid explanation why the petitioner slept over the matter and approached the chairman with a representation only 17 years after the order of removal. With the delay not being satisfactorily explained, the learned single judge cannot be faulted for declining to interfere in the writ petition. The appeal is accordingly dismissed.
Item number 61.
Okay. My lord, this is a PIL matter regarding the misappropriation of the government fund.
You go to the loci, sir. If the cause of action survives, it will be open to the appellant, a petitioner, to approach the loci in accordance with law. Okay. The petition is disposed of.
Weekly list item 62.
Well, this is a PIL matter, Miller. I am a BC Miller. In this case, Miller, the petitioner has filed the case that the opposite, some villagers across the village roads and sold the village, the Gram Panchayat lands, Miller, for which he could not able to construct the developmental work done by the Panchayat Samiti, Miller, for which he gave the representation to the Taldar, and Taldar initiated the encroachment case against those encroachers, Miller. And thereafter they filed the appeal before the sub-collector, Miller, and the sub-collector was pleased to reject that all the appeals, Miller, provided that, Miller, in spite of that order, Miller, till date that they have not been evicted from the government land for which the Gram Panchayat could not able to do the developmental work of the Gram Panchayat, Miller, for which the PL has been filed, Miller.
What's happened in the last 6 years?
My lord, they are playing hide and seek with the petitioner could not able to do all these things, Miller. Due to muscle power, they are doing all these things, Miller. In spite of
who are the encroachers, sir?
My lord, the encroachers, there are so many persons there, my lord.
No, have you implemented any of them?
No, my lord, we have not implemented them, my lord.
Then?
My lord, we filed the case, my lord. That
without implementing the encroachers, how do you expect orders to be passed against them, sir?
My lord, the sub-collector order has been passed, and against that order, nothing has been done by the villagers, my lord.
You say the present petition has been filed seeking removal of encroachers without actually making the encroachers parties to the writ petition. Consequently, the petition cannot be entertained in the present form. Paragraph. It will be open to the petitioner to seek appropriate remedies, bracket, if if the cause of action survives, by filing, first making a fresh representation, naming the encroachers, and thereafter seeking appropriate remedies in accordance with law. The petition is disposed of in the terms.
Item number 63.
None appears dismissed.
Item number 64.
Admit the trial court record with requisition. The paper books will be prepared within 8 weeks and then supplied to counsel of the parties. Thereafter, matter be included in the list of final hearing matters. Realization of fine amount to state. This bail application is not tested at this stage. Disposed of. Oh, there is no bail application. Only this. All right. This is disposed of.
Weekly list item 65.
My lordships,
Defect number 22 not removed. Defect number 22 not removed. What is that defect number 22?
Lord, waiting for the time period of 60.
The PIL rules had to be complied with. Happened.
Lordship, in the last date, while presenting, you'd asked for conducting, like, who are the petitioners and who are the aggrieved students to which
That, of course, that apart, you have to make a representation on their behalf too. So do you know who are the aggrieved students?
Lord, we did conduct a survey, and may I at least request, like, if the matter be taken up after lunch, I could be present in court and...
Your colleagues in the bar have different ideas. They want a reference today. So they're not letting you do that after lunch.
Well, then I may be allowed to present, although I had prepared a report which I wanted to hand over. And we did conduct a survey, which was a twofold survey. One where the petitioner, the chairman of the petitioner organization, and even I had accompanied them to 5 private schools. And along with that, we also did a second online survey, which was done through Google Forms, and students from across Odisha and even outside Odisha had filled in their responses in this form.
And what is the result?
Well, then, if I may be allowed to share my screen, I can...
No. I think you have it. Counsel for the petitioner seeks some time to present, to place and record the results of a survey purportedly conducted by the petition organization.
Lord, can it be taken up tomorrow?
File it with an affidavit. You say the report be placed with an affidavit, along with an affidavit, before the next date. We'll take it up soon after the vacation, 11th October.
All the students have been waiting for this, and the admissions which are going to close in this week. So some of them might not even get admitted in the college.
Can't be helped. It can't be done like this. It can't be done in a one-day's hearing, and so many parties have to be heard. The issue itself is a complex one. Yes, 11th October.
Weekly list item number 66.
In this case, I have filed an amendment petition. Amendment first of all allowed. The new establishment has come with from 1/6/2020.
What's the delay?
Tata Power.
What's the explanation of the delay?
A delay, my lord, only 3 to 4 months, and official procedure.
108 days, sir. 108 days. Are you aware of the case law, sir, now?
Yes, my lord. I was, my lord.
What does the case law say, sir?
The case, my lord.
No, what does the case law on delay say?
Delay, my lord, only 3 to 4 months.
What is the judgment, sir? What is the latest judgment of the Supreme Court on that? Are you aware of the judgments of the Supreme Court?
Tomorrow.
I will tell you, sir. We'll educate you. There is a judgment called
3 to month officially procedure. We are.
There's
Now what happens, my lord?
There is a judgment called Living Media India Limited. Are you aware of that?
No, my
There's
lord.
a judgment called State of Madhya Pradesh versus Bherulal. Are you aware of that?
Delay, I will already explain in my.
Let us see, sir, what explanation you have. Let us see the explanation.
My limitation petition, my lord.
Yes, let's see that, sir. Sought for instruction, legal opinion from counsel. These are grounds that the Supreme Court has rejected, sir. These are grounds that the Supreme Court has refused to accept for delay. All right. There's a
My
delay.
lord, and para 3, I have detail explained, my lord.
Yes. That is precisely what we are reading.
My lord, kindly, delay is, my lord, for a corporate body, it is nothing, my lord. It is very.
I know. That is your understanding. The Supreme Court has a different idea, sir.
My lord,
your understanding is different.
My lord,
you're entitled to your understanding, sir. But the Supreme Court has told us differently.
Adoption of official procedure, the delay has been caused.
Correct, sir. Correct.
So,
sir, in your leisure time, what you do, sir?
No intentional or deliberate.
In your leisure time, please read the judgments. We're going to refer to those judgments.
Yes.
In your leisure time, you read it.
Yes, sir.
You say there is a delay of how many days? 108 days in filing this appeal. The explanation offered in the application for condition of delay is as under. Reproduce para 3 and 4. The above kind of explanation has not been accepted by the Supreme Court in a series of judgments, including Director General of Posts versus Living Media India Limited and State of Madhya Pradesh versus Bherulal. Further, the Supreme Court has, in a more recent judgment, set that judgment, observed as under. Reproduce the whole paragraphs. with the explanation for the delay being unsatisfactory, the court is not inclined to condone it. Accordingly, IA number 623 of 2019 is dismissed. Consequently, the appeal is dismissed.
Quick list item 67.
My lord, after vacation,
Dismissed.
Who's in 67?
Item 67.
My lord, item 67, I appear for the appellant, my lord. The appellant here is challenging an order dated 14/3/2022 passed by the learned single judge, where the learned single judge refused to exercise the jurisdiction in relation to writ petition filed under the Consumer Protection Act. My lord, the brief facts of the case is that, my lord, the learned consumer forum had misplaced the files in relation to the case, my lord. And thereafter, that has also been acknowledged by the president of the DCTRF, my lord. And thereafter, a writ petition was filed. Learned single judge relied upon Sicily's judgment of the Supreme Court. That is on a different context in relation to appealable orders under the NCDRC vis-a-vis the Supreme Court, my lord. My case doesn't fall under that category. And therefore, my lords, therefore, I pray your
No, but
lordship.
why 1 minute?
67. My lord, 67 is 397 of 2019 writ appeal. Serial 22.
No, 397 of 2022, sir.
Yes, my lord, 397.
Oh, sorry, it is my wrong file.
My lords, my case is entirely on a different segment, and the learned single judge.
No, what were you challenging before the single judge, sir?
My lords, my context was that, my lords, my case in relation to the District Consumer Forum were missed. Therefore, I was seeking for a reconstruction of the case files.
Oh, I see.
And that has also been noted in the single judge order, which is at page 18, my lords.
All right. You see it. Notice is accepted on behalf of the state. There is opposite parties 1 and 2 by Mr. Monty. Notice to the other parties returnable 13th December. The tracking report will be placed into copy.
Item number 68.
May I please, your lordship? Well, this is an order against an order of the Honorable Single Judge, remitting the matter for imposition of condition under 22 of the OLR Act. Whereas my humble submission before the Single Judge was that no condition could be imposed because it is a clog on transfer. The Honorable Single Judge takes note, page 6 of the impugned order, your lordship may kindly see.
Yes.
This court perused the scope under section 22 of the OLR Act finds then the competent authority has very limited role. Considering the rival contentions of the parties, this court finds there is no dispute that the public authority has responsibility in exercising its power under 22 of the OLR Act, also to protect the interest of the SC/ST people involved therein. In the event the competent authority was of the opinion that there was likelihood of suffering by the SC, nothing prevented the public officer to pass practicable order in disposing to OLR application. Reading the order passed by the competent authority in exercise of power under 22 OLR Act and the conditions so imposed, this court finds there has been already allowing of permission for sale of the land involved, but condition imposed appears to be stringent, ultimately making the permission ineffective. In the circumstances, then he remands the matter for consideration of fresh conditions.
Yes.
Whereas section 22 doesn't prescribe of imposition of any condition, only competent authority is to see whether any person belonging to SC is able to purchase the land or not. That he finds, I have annexed in the writ petition, your lordship may kindly see, page 10 of the writ petition. Page 10 of the writ petition.
Yes.
Clause 5. There are only 10 numbers of SC families living in the locality, so and so, and none of them is showing interest to purchase the case land. Thereafter, permission was granted.
Yeah, that's only. I've been reading also.
What was the condition?
Condition, page 11. Page 11.
Writ appeal.
Page 11, no, in the writ petition.
Writ petition, nahi.
The writ petition also, page 11.
Page 11 is the condition, my lord.
last but one paragraph. In view of the elaborate discussions made supra, I am satisfied with the prayer of the petitioners. Hence, I am inclined to order that the application filed on behalf of the petitioners praying to accord necessary permission to sell the case land to any of the member of the non-SC community is prone to be allowed. So it is allowed, subject to the condition that the applicant is required to purchase equal area of land of any kisam in Malkanagiri registration district, and the registration of both the lands should be made at a time.
Okay.
And the Honorable Single Judge finds this condition
Collector is more conscious because it is in Malkangiri district. Your Lordship knows that is a scheduled caste covered district. So that is why I think he has imposed this condition.
No, scheduled tribe, I suppose.
Scheduled tribe, yes, my lord.
Is it scheduled caste or scheduled tribe?
Scheduled caste.
Section 22 is scheduled caste.
So why should they purchase? Why should he purchase another equal area? He wants to sell the land. How can he be permitted to buy another land?
Honorable Single Judge has directed to reconsider this. Let us see what the subcollector is doing after.
Then again, I will be facing another round of litigation, and the land could not be sold. And 22 doesn't prescribe any imposition of any condition.
Yeah. You see, the counsel for the appellant contends that Section 22 of the OLR Act, which permits the. This is the collector, is it?
Subcollector.
Subcollector. Malkangiri.
To exercise powers of granting permission for sale of land in an belonging to the persons of the scheduled caste. Not to impose any further condition, except ensuring that the conditions stated therein stand fulfilled. Full stop. Here, despite finding that all the conditions for according such permissions stood fulfilled, the subcollector imposed an onerous condition on the appellant to purchase an equal area of land in any kasam in Malkangiri registration district. Full stop. The learned single judge has, while setting aside the said order, remitted the matter back to the subcollector, which according to the counsel for the appellant was not necessary. What do you say? You are the only party here.
My residual submission is that it is a fact that Section 22 nowhere provides to impose certain, but it is the prerogative of the subcollector, and he has to exercise its judicial mind and give protection to the scheduled caste persons. If he has done this because
the person selling it is what? He doesn't belong to the scheduled caste.
Yes, I am a
non-scheduled. That's what he already belongs to the scheduled caste only.
No. The seller is a non-scheduled caste.
No. The seller is a scheduled caste.
I'm sorry. Seller is a scheduled caste.
Buyer is asking for permission to sell to a non-scheduled caste.
Non-scheduled caste. So if land of scheduled caste person is going away.
That's right. They only have to ensure that there is no other person who's a scheduled caste is willing to buy. That's why a public notice is issued. Once a public notice is issued, no objection is received, then you have to grant the permission. How can you compel the scheduled caste person to buy while he's selling the land? He may want to.
And another thing is that subcollector to ensure that scheduled caste will not be landless. That is also another criteria.
No, but the
landless part is also to be, because once he sold the
but he's asking him to buy. It's not that he's saying, okay, you're losing land, we are giving you, government is giving you land. He's saying if you're selling the land, it's like your
so whatever
capital gains tax.
Yes, your lordship.
You have to invest in another.
Whatever consideration money, he has to buy some land because
why should he buy? What is 22?
Yes, that is what I'm saying. Because the ultimate objective is that he should not be landless.
No.
Because
if he's selling, sir, the whole idea is that he needs money, he's selling it. If you are very concerned that he should not go landless as a government, you grant him land then. You cannot compel him to buy land.
had there been any case that a part of the land
If your
is being
concern
sold,
is that he should not go landless, then you cannot compel him to buy.
because he is
Well,
selling his
section
entire
22.
property. He is
No,
selling his
that is,
entire
that is also not correct. Clause
Where
11.
have you said so?
Clause,
That is not
yes,
there.
you don't have file that does. Clause 11. you
Yes, I don't have
see.
file. It is a fact. Because
Very
read
bad.
petition file is not available. Only read appeal, there is no annex.
Clause 11. That page 10 of the writ petition. Page 11. Clause 11. After sale of the case land,
There remains balance landed
there
property.
remains balance
Few
landed property.
hectares. Sufficient to maintain the livelihood.
The
That
only,
is, everything has been
the
recorded.
only predicament is that the read petition copy is not with me.
All
Not
right,
the
then you
file.
take time. All right. All right.
Yes, your
Just
lordship.
simply say this, then simply say notice. Mr. Mohanty accepts notice. A complete set of the papers, including a copy of the writ petition, be served on Mr. Mohanty forthwith. List on 29th November. All right.
May I pray shorter date because the mother is suffering from spinal diseases.
Oh, I see. All right. List on 26th October. All right. Sorry, 27th October. Make it 27th October. All right.
Weekly list item 69.
May I please, Your Lordship, my lord, I am on BC. My lord, the appellant challenging the order passed by the learned single judge in dismissing the writ petition. My lord, the petitioner made application, writ petition for a seeking prayer for a direction to the opposite party bank to reconsider his application for reschedule of loan by adding overdues as fresh loan and.
Sir, all this is what this is a consumer financial Indus Bank must be before the DRT.
No, my lord.
No. What is it covered by?
My lord, my boss has been seized and repossessed and going to auction. So my prayer is only to pray, only to direct the opposite party bank to reconsider my application for reschedule of the loan and to deliver.
No. What is the amount that you owe the bank?
It was around 3,20,000 was as on 21/12, and out of which I have already paid 2,88,000. And after release of the boss, they again repossess after 1 month, 10 days of the release. So I pray, my lord, to deliver the boss.
No. This is a private bank, sir.
My lord.
IndusInd Bank is a private bank.
My lord, my lord.
Oh, how can you file a writ petition?
My lord.
How is it maintainable, sir? How is a writ petition maintainable?
My lord, they accept sufficiency act. It is not.
No. Writ petition is not maintainable, sir. Sorry.
My lord.
The present appeal is directed against an order dated 12th September 2022. Passed by the learned single judge dismissing the appellant's writ petition civil 19872 of 2022, in which the petitioner was seeking relief against a private bank, which was the sole opposite party. Clearly, a writ petition was not maintainable.
My lord,
and therefore, the learned single judge rightly observed that the prayer made in the writ petition for a direction to the bank to consider the application filed by the petitioner for appellant for rescheduling the loan, the court is unable to find any error having been committed by the learned single judge. That calls for the writ appeal is dismissed. Yes.
My lord, my prayer is to direct the bank to release the boss on payment of 50% outstanding.
Correct, sir. That has to be in some other forum, cannot be in a writ petitions. Yes.
Item number 70.
The consumer court is not allowing on the ground that you are in High Court, so will not pass. My lord,
actually, sir, if you come to the wrong forum, nobody can help you, sir. That's right.
My lord, kindly give liberty to.
That you always have, sir. This will not prevent the petitioner from appellant from seeking other appropriate remedies as may be available to the appellant in accordance with law. All right, call out 70.
Item 70.
May I please, my lord? My lord, I am seeking order. I filed this PIL seeking direction under Annexure 7. My lord, if my lord will see the ROR in Annexure 1, the land belonged to state government and the temple authorities of Puri Jagannath Temple. And this land is just behind the temple. This land was granted for the purpose of Dharamshala for traveling pilgrims from far off districts and states to stay there when they come for darshan. Now the private encroachers have taken
Give it a
over.
representation.
Representation is under Annexure 7.
Or
And
Annexure-
petitioner's representation.
1 minute, my lord. Annexure 3 is the representation, I think, given to Collector Puri.
May I clarify? Annexure 3 is not representation. We have tried to intimate the government several times. Then Annexure 5 series, we have tried to intimate several times.
Annexure 7.
And Annexure 7 is pursuant to Rule 8 of the PIL rules. Along with the
Annexure 7.
Annexure 7.
Where is the proof of delivery of that representation?
Proof of?
My lord, the only thing I want to point out, both the representationists, one is from Rourkela, another is from Kolkata. Nobody is from Puri. This is a PIL relating to Puri land. Lordship may kindly have a glance. And so many persons have signed the representations. All are of Puri town, but nobody is before your lordship. All these two persons, Rajiv Mahanti is from Rourkela, Subhasis Banerjee is from South Road, Kolkata.
Public interest petitions all over India.
That is correct, but this is how
everybody is concerned about land in Puri Jagannath. Yes. What is the proof of delivery of the representation?
There is no proof.
No proof. You make a fresh representation.
Lordship,
permitting the appellant to make a fresh representation.
I have the proof, my lord.
Where is that?
If there is proof, then
Lordship, 1 minute, please. Lordship, page 45.
Is 45.
Postal receipts.
All right. Petitioner's representation, bracket Annexure 7, will be examined by the
collector, my lord.
Collector Puri.
All right. Collector Puri, and after notice to the petitioners as well as opposite parties.
My lord, after hearing the petitioners
and the temple administration.
Your lordship may direct after hearing the petitioners.
And after hearing them. And after hearing them, a reasoned order shall be passed. Not later than 26 December 2022 and be made available to the parties within a week thereafter. The court clarifies it is not expressed anywhere in matter.
Obliged, my lord.
Weekly list item number 71. 71.
In person.
Representation, 2nd September.
My lord, for serial 71.
So you have given us representation only on 2nd September, sir.
Yes, my lord. My lord, it's a very urgent matter.
I know.
Because, madam, about 4 lakh poor family.
So let them consider it urgently, sir.
My lord, I'm not getting.
He sent it by email.
My lord, since last 8 months. And spending foodless nights, my lord.
Yes.
It is clear violation of fundamental rights, my lord.
Correct, sir.
Guaranteed under Article 21 of the
So we'll ask them to consider it immediately, sir.
And my lord, in this
so we'll ask them to consider it immediately. All right.
Okay.
The petitioner's representation dated 2nd September 2022, bracket Annexure 15, be examined by the Secretary, Food and Civil Supplies Department, right?
Yes.
At the FCI, madam, Food Corporation.
Secretary.
My lord, he is saying that FCI should consider Food Corporation of India. Yeah,
my lord, right to life involved in this case.
No. Whom do you want it to be considered by, sir? You better be clear.
Government will consider this. As per the Government of India scheme, the state government need to consider, my lord. It's better to direct the state
by
government.
The Principal Secretary, Food Supply and Consumer Welfare Department, Government of Orissa. And after giving the petitioner, as well as all other entities who may be concerned in the issue, including the Orissa State Civil Supply Corporation Limited and Food Corporation of India, and giving them a hearing.
My lord, it is the latest
a reasoned order shall be passed not later than 14th November 2022 and be made available to the parties within a week thereafter. The court clarifies it is not expressed in the matter. All right.
PR for number 2 उसमें appearance में भी noted है.
Weekly list item 72.
All right.
Item number 72.
Yes, I am there, my lord. The UCO Bank is before your lordship challenging the order of the learned single judge. List of dates and one additional list of citations I am handing over to your lordship. What has happened here, my lord? There is a stay order in my favor since 12/1/22. Your lordship may see.
So what is the delay, sir?
Delay, my lord. If your lordship will see there are two things I want to point out to your lordship.
First, tell us the delay, sir.
Yes, if your lordship take the decision of the Supreme Court on the suo motu extension, then there is no delay.
How come?
Yes, my lord. That is why I wanted to show your lordship two things. Kindly turn to page 100. What has happened in this case, my lord?
When was the impugned order passed, sir?
My lord, 5/2/2020. Why I wanted to show page 100?
Before the COVID started, sir.
That is what I wanted to show your lordship, my lord.
Yes.
My lord, there are two things I wanted to show your lordship. The first is, in this case, the UCO Bank, though lawyers appeared, filed the wakalatnama, they did not appear when the final order was passed. That has been recorded by the single judge. No counter affidavit was filed. Secondly, my lord, we have got the order on 2nd September 2020. This order, which we of the learned single judge, we have received. So, my lord, the first decision I wanted to place in my list of citations is the limitation will begin to run from the date we have received it. And the third thing I wanted to show is if your lordship will see my
So
miscase.
these days, orders are uploaded on the net. You don't have to wait for receiving a copy of the order.
That time we have no lawyer was representing the bank. The bank was not aware that the final order has been passed. That is reflected in page 100. That is the first page of the impugned order. Lordship may kindly see that. Then my lord may kindly see page 106 when we received copy of the order. There is a letter of this Honorable High Court, my lord, where you have received and the seal is there. And thirdly, those lawyers are no longer in practice and we had to obtain certified copies of the entire writ petition, annexure certified copies there. And fourthly, if your lordship will see, I have given that judgment of the Honorable Appellate Court suo motu extension. There, if that is taken into consideration, then there is no limitation. That is why this Honorable Court stayed the matter on 12/1/2022, my lord. Kindly see my lord's order dated 12/1/2022. This very question was asked by me, my lord, and I have satisfied prima facie. That is why the stay orders was passed in my favor.
No, you got a copy of this order in September 2020.
Yes, page 106 may kindly be seen, my lord.
When did you file this writ appeal?
My lord, I filed in 2021, my lord, because none of the papers were available with me. And the lawyers who were, yes, lordship may kindly see my miscase. I have specifically pleaded that at page 4, 5, and 6. That the lawyers who are conducting the cases.
Notice on the delay application first. It's a notice on the delay application.
My lord, the lawyers, somebody was appearing because on the first date, nobody appeared. Then I gave another address. This is the first date, I think, for the appearance, somebody is there.
My lord, namaste. I am a son of a respondent. I want to speak in Hindi. मैं जो एडवोकेट को दिया था वो थोड़ा नेग्लेक्ट करने से मैं उनसे काउंसिल रिटर्न कर लिया.
तो आप वकील रखना चाहते हैं?
मैं कुछ प्रूफ के साथ भी बता सकता हूँ. मैं इस मैटर में
नहीं, आप वकील रखो. आपको लीगल एड का वकील चाहिए?
जी हाँ, वकील तो चाहिए, मगर मैं अभी भी बता सकता हूँ क्या केस है.
My lord, the respondent was working as a assistant manager advance. There are certain financial irregularities.
1 minute.
And he was.
आप उनके बेटे हैं क्या?
जी.
और
actually my respondent has been suffering from paralysis since 19 July 2013.
Oh, I see.
Yes, sir.
Okay.
मुझे एक मौका देंगे तो मैं इसके मैटर में मैं शुरू से बता सकता हूँ.
मगर कोई वकील हो तो आप रिप्लाई फाइल कर सकते हैं ना. इनका डिले का भी एप्लीकेशन है, उसका जवाब भी देना है आपको.
जी.
हाँ,
वो जो बोल रहे हैं
आप वकील रख लो पहले, हम वकील दिलवा देते हैं. The son of the respondent appears and explains that the respondent is suffering from paralysis. Clearly, it appears that the respondent is not in a position to engage any lawyer to defend himself. A complete set of the papers be handed over by the registry to the Orissa High Court Legal Service Secretary, Orissa High Court Legal Services Committee, to assign a lawyer of not less than 10 years experience to appear on behalf of the respondent in the present writ appeal. You just give him, आप वो secretary का number ले लो, वो आपको वकील का नाम बता देंगे, जो वकील दिला रहे हैं आपको, उनका नाम बता देंगे आपको.
मैं इस केस में बारे में मैं जानता हूं.
उनको वकील को समझा देना पूरा, वो वकील फाइल करेंगे रिप्लाई. ओके. And just this IA for delay, you say notice on this IA. Notice is accepted on behalf
My lord,
of respondent by
notice is already
Sanu's
gone on main case and delay and stay all. Already twice it has gone. First time what I wanted to, nobody appeared. Then we gave another address. So pursuant to that, they are appearing today for the first time before your lordship.
All right, notice is already gone. Okay, reply be filed to the application for delay before the next date. Interim order to continue.
Obliged, ma'am.
List on 19th December.
Obliged.
Item number 73.
May I please your lordship, my lord? In earlier occasion, your lordship was pleased to admit the writ appeal
Just give him a
as well as
73.
Item 73.
may I please your lordship, my lord? In earlier occasion, your lordship was pleased to admit the writ appeal and also granted interim stay. As this note is concerned, the registry indicated a defect, that is, I have to file certified copy of the impugned order. So I humbly submit, my lord, I will granted 1 week time to file the certified copy of the impugned order. That is the defect number 9.
Defects be removed within a week. What about service notice, sir? Service of copy AG. You did not file the requisites, sir.
My lord, I have filed.
When did you file?
My lord, I have already filed all the requisites.
When?
Sorry, my lord, I cannot also express exact day, but I have filed.
We go by our registry's noting, sir. They have said that you have not filed the requisites.
I may permit to file affidavit. I have already filed, my lord. I never mislead the honorable court, my lord.
Not for misleading, sir.
So far, office note is concerned.
It's not filed as the noting.
My lord, I have already filed requisites. I have already filed, my lord. I can't exact day, my lord, but I have filed.
Incomplete requisites, sir.
My lord,
not filing.
My lord, so far office note is concerned, office note indicated, say you have
It
to file.
appears that the requisites filed was incomplete. Counsel for the appellant prays for one more opportunity. Defects have also not been removed.
Defect already removed. One defect is there, that is I have to file certified copy.
Sir, we can't hold an inquiry here. Sir.
Oh, obliged.
If you want to do that, then we'll just vacate all this interim order. You first satisfy the registry. You cure all the defects and then we'll take up the appeal. You say the interim order is vacated because the learned counsel for the appellant wants to satisfy the registry about removal of defects. List after all the defects are removed.
Interim stay may be continued, my lord.
No, sir. If the defects are there, we don't continue the stay.
Sorry, my lord, I have actually for sake of the interest of that may be continued.
Let's see, sir. You first cure the defects. Yes.
My lord, interim order, there is a.
You first cure the defects.
My submission before your lordship, my lord. This is a culvert, my lord. Regarding the culvert, the dispute arose. It is not my personal interest, my lord.
Yes.
Item 74.
Yes.
If permitted to please, my lords. The defects pointed out.
Have to be removed, sir. First, remove the defects, sir.
Yes, I have already solved copies. Only mobile numbers are of my.
Whatever defects we removed within a week, list thereafter. Yes.
75.
Similar items, 74 to 78.
Yeah, both. Yeah.
Up to 77.
Yes.
To 78.
All right.
Weekly list item 79.
My lord, on behalf of Mr. Sahu, I pray for next week, my lord. The paper book has not been received by him, man.
So this paper book will not be delivered to you by post or something, sir. Paper books are available. You are supposed to collect it. This is a 2011 matter. The man is sitting in jail, correct?
My lord.
Is the man sitting in jail? Is your client sitting in jail, sir?
No, I have not only.
Whom are you, sir? First of all, let us understand. Can you give us your name, sir?
On behalf of Pachutananda Patnaik, my lord. On behalf of Mr. Sahu, my lord.
Where is Mr. Sahu, sir?
He is court number 12, my lord.
We'll wait for him, sir. Tell him the Chief Justice's court is waiting for him. Kindly ask him to make it convenient to come here.
My lord, my lord.
All right. Pass on. And keep the paper book ready so that give it to him.
Item number 80.
My lord, in item number 80, my lord, I am pressing for the interlocutory application number 51, my lord, for interim, my lord. My lord, the appellant is in custody since 31/3/2011, my lord. More than 12 years, my lord. My lord, is the father's left ligament has been
Yes, my lord. We
fractured.
have called for instruction, my lord, but we are yet to receive. If your lordship will give me a short date, my lord, I'll get back to you, lordship. We had called for instruction on 5th of August.
He's already spent 11 years in jail.
It's a connected appeal, my lord. There are almost
My lord, his mother is also died, and his wife also died, my lord. Appellant's wife and mother. No one in their family members, my lord, to look after his old father of.
See, last time we adjourned, this was listed on 22nd August. Nobody appeared.
My lord, in that
we had passed it over, still nobody appeared. If it is so urgent, how come you are not appearing in the matter?
My lord, I am wrongly seated at court number 1, my lord.
See, just see how serious you are about these matters. Which is this IA you're pressing, sir?
My lord, item IA number 51 of 2022. My lord, 1 month time, my lord, maybe.
The father is 106 years old.
But the report says that it's some orthopedic problem. Nevertheless, my lord, I'll just.
He's bedridden, unable to walk or stand.
Yes.
He requires surgical operation. That's what he says.
We had called for instruction on 5th of August, my lord. I'm sorry, my lord, because of this.
IA 51 of 2022, Council learned AGA for the state seeks some more time for instructions. You'll have to have it in the opening day now. How soon can you get instructions? Should we have it on Friday?
Yes, my lord.
All right, Friday. 30th, sir.
Weekly list item 81.
Please, my lord, I'm appearing on VC minutes. Minutes here, this is a petition for bail of appellant number 1, who is the mother-in-law of the deceased minutes. IA 519 minutes.
All right. How many years has she spent in jail?
Minutes, she was in bail during the trial period, Millets, and now she's been convicted to sentence under section 490, 304B, 306, read with 34 IPC, Millets. And she has been arraigned for 3 years, 7 years, and life imprisonment respectively.
No. So the judgment is of 15th March, which means she's been in only since 15th March.
Yes, my lord.
Which is not even 6 months.
I agree.
Just about 6 months. Just about 6 months.
My lords, the deceased has a minor son, my lords, and there is no other relative to look after him, my lords, as the father is also in custody and there's no other relatives on the father's side.
You want to take instructions? You have instructions on this?
No, I don't. This first time it has come, I'll take instructions.
All right. IA 519. Counsel for the state seeks time for instructions. This appeal is not
admitted.
It is admitted, my lords.
25/7 it was admitted.
All right. List on, we'll have it after the vacation. List on 12th October.
Item 82.
Be admitted.
Item number 80.
It's coming first time. All right. Admit. The LCRB requisition. The paper books be prepared within 8 weeks thereafter and supplied to consular
Lordship,
parties.
I'm item number 82, Lordship.
Stay of realization of fine that is allowed.
Yeah.
And bail not pressed at this stage. All right.
Published.
Item number 83.
My pleasure, Lordship. The appellant is
Admit the LCRB requisition, paper books be prepared within 8 weeks thereafter. Stay of realization of fine. That's allowed. Bail not pressed at this stage. All right.
Weekly list for admission, item 84. 84, sir.
My lord, they have partially complied the order by demolishing that has the house, leaving that building intact.
What's happened, Mr. Monty?
Yes, my lord.
On 28th August, they have demolished that part.
On 28th August, that is a simple instruction I have received, but detailed instruction I have not received.
Mr. Monty seeks some more time to file an affidavit of compliance. The affidavit possibly be filed on or before 17th October 2022. List on 27th October.
Weekly list item 85.
85 matter relates to grabbing of property of the DT. The opposite parties have filed a counter. In its counter at page number 3, the economic offence wing has stated that the property of the DT has been grabbed in connivance with some officers, my lord. They have suggested that it has not been complied, the law has not been complied, but action has not been taken, my lord. My prayer was that those who
this matter was listed last on 19th August 2014.
My lord.
And not listed for 8 years.
My lord, so several memos have been filed, my lord. Unfortunately, it is not listed.
Sir, unfortunately, my memory is good, sir. I have sat here in this court from January 2021. Tell me how often, Mr. Raut, tell me how often did you mention this matter to me?
After your lordship.
So I also join you in saying, unfortunately, you have not done that.
I've not mentioned, my lord. That's right.
What is the urgency here and why is the issue still pending?
Pending, my lord.
I think it's actually not an urgent matter. We made the mistake of listing it, correct? It's actually not an urgent matter at all.
Urgency is there, my lord. But they have filed a petition under section 41, my lord, in the meantime. The land grabbers have filed a petition before the assistant commissioner, my lord.
So you participate in those proceedings, sir. That's the best.
Matter is all seized in before the endowment.
It appears that matters are already proceeding under the Orissa Hindu
Religious Endowment Act.
Religious Endowment Act before the appropriate authority. This is acknowledged by counsel with the petitioners himself. Permitting the petition to participate in such proceedings, the court does not propose to keep the present petition pending and it's disposed of as such. Right.
Item number 86.
Obliged.
Yes, Mr. Monty.
May I please? My lord, kindly have a glance to IA number 9890 for amendment.
Yes.
Here, my lord, the fact is illegal conversion of residential buildings into commercial building to run private boys and girls hostels. Here, my lord, under the Orissa Municipal Corporation Act, the power has been delegated to the Commissioner BMC and CM, wherein the Commissioner of Police, Urban Police District, Bhubaneswar, Cuttack, is exercising the above power in view of a notification. That is under challenge. My lord, the draft regulation is before your lordships. Without taking liberty, they have finalized it, for which I have filed this amendment.
We allow this amendment, sir. We allow this amendment. 9890/22 for the reason stated, the amendment is allowed. What about the consolidated petition?
My lord, I will file. My lord, within
consolidated petition be filed within 10 days. Note on or before 10th October 2022 with an advance copy to counsel for the state who is permitted to file a further reply to the amended petition.
I'm appealing for BMC, my lords. In this case, my lord, I'm appealing for BMC. A copy may be served.
Yes, as state as well as BMC, who are both permitted to file replies to the amended petition before the next date.
Obliged, my lord.
List on 4th January. Right.
Weekly list item 87.
In this case, my lord directed us to file the suggestions. They have submitted suggestions.
Your lordship,
my lord, only thing to submit to your lordship that it appears that
making effort to make some arrangement for protection. But this effort was made in 2013. 9 years after, they are again suggesting that we will do this. Hathi corridor, this is written in Oriya, Hathi corridor nirmana by prastuti. Making effort for protection of elephant. But 13, my lord. 9 years have passed. 9 years after the government is coming, that we have to make effort. Well, this your lordship to visualize how things are going on. And my lord, my humble suggestion to my lords is, your lordship must fix up a date by which date they are to complete, if at all they are to make some efforts.
My lord, our specific stand is by the end of December, we will complete the comprehensive action plan. Task force has already been constituted by order of this Honorable Court. And they have already met once, that is on 28th of September. And the matter is under the process and will complete the process within 2 months max.
An affidavit has been filed.
Process they have completed, we can see it. No, I personally, I can visit those places.
We will complete.
Yes, you give us details.
Setting
I'll
out
go and see the places.
Steps taken by the joint task force since the previous hearing. It appears that the first meeting of the JTF was held on 20th September 2022. And the decisions taken at the meeting have been set out in detail in para 5 of the affidavit. Copies of the affidavit be supplied to all the
I'm supplying copies
appearing
to
to
all.
the other parties to enable them to file their response there before the next date. Paragraph inter alia, it has been proposed that the comprehensive action plan will be prepared by December 2022. The affidavit acknowledges the further deaths of elephants since the last date of hearing, and about action being initiated against forest officials besides DISCOM officials for negligence. Stop. This for further hearing on. We'll have it after the vacation. 20th October, 20 October.
My lord, November will be more preferred because
No,
in
let
the
it be in
meanwhile
October. No, let it be in October. Let it be in October, sir.
Okay.
Let it be in October. Right.
Item number 88.
My lord, in this case, processor has been completed, and my responsibility with due diligence, my lord, the Annexer 1 passed by the Lord and single judge, my lord. Sorry, Annexer 2 passed by the Lord and single judge. Please make a glance. Page 12 each hereby challenge. Lord and single judge, however, dismiss the writ petition on the ground of maintainability shall not preclude the petitioners to agitate the issue before the appropriate court, my lord. Before going to the Annexer 1, please make a glance to the my response submission. Please make a glance to the Annexer 4. That is also another single bench order, my lord. The case of the humble petitioner like this, my lord. The humble petitioner also got appointment as Anganwadi worker, my lord, on 17th July 1983, my lord. And seeking the promotional review, he knocked at the door of the Honorable High Courts, my lord, and Honorable High Courts by disposing the Annexer 4, passing a error, my lord, long error.
How does this? How can it be dismissed the first stage like this? Why is it, if it's an appointment, is a civil post, why can't a writ petition be filed?
What has happened in this case, when first writ was filed, at that point of time, she was an Anganwadi worker. Subsequently, by virtue of my lord's order,
becomes the supervisor.
Yes, madam. And he holds the post of civil post. So at that point in time, a state administrative tribunal was functioning.
Now there is no state administrative.
Now that there is no.
So it has to go back then.
Just honorable single.
The impugned order dated 12th January 2018 of the learned single judge has dismissed the appellant's writ petition at a stage when the Orissa Administrative Tribunal is still functioning. And perhaps the writ petition was dismissed on maintainability on the ground that the appellant should approach the OAT, paragraph. Now that the OAT stands abolished, that remedy is no longer available to the appellant. The impugned order dated 12 January 2018 is accordingly set aside, and writ petition civil 115054 of 2016 is restored to the file of the roster bench of the single judge, to be listed there on 21st November 2022. A reply to the petition shall be filed by the state on or before 14th November 2022, and rejoinder there to be filed before the 21st November 2022 by the petitioner. That is the appellant hearing. No further time will be granted for that purpose. The learned single judge is requested to proceed to hear the writ petition on merits and dispose it off as expeditiously as possible.
Item number 89.
Obligement.
Yes.
No.
This is the application I have challenged, the single judge order.
Stands at 1612.
No, my lord, the previous judge was adjourned for 3 months. When the court, I was ready for argument, and honorable court passed for 3 months. Then also again, my uncle's funeral function on that day, 4th-8, he adjourned to 4th-8 to December. That's why I again mentioned before, Lord, because it relates to appointment. And all the pleadings are complete.
Only difficulties today, there's a reference.
Tomorrow, because it is a matter to relate to appointment, all the pleadings are come. May not be today, but nearer, not like December. I'm being before client. My after numbers are being disposed of by island.
All right. List on 18th October.
Okay.
List item 90.
Your Lordship, in this case, I have filed a written. Actually, as my lords told just now, that there is no lunch, no court after lunch, Your Lordship. 10/12/2021. I have filed a written, and this requires the full hearing, Your Lordship. If Your Lordship fixes immediately after the vacation, any day, Your Lordship.
Yeah, 19th October.
19th.
Well,
Yes.
pardon, Your Lordship, I also have filed the written note of submission. On that basis, Your Lordship may dispose of the matter, because since 2018, 27 writ appeals are pending, and this is the first one, and stay is continuing since 2018, Your Lordship. It may be disposed of if my learned senior is agreed to that, because he has also filed the written note of submission. I have also filed my written note of submission.
He won't want to argue. I think.
Same thing.
Your Lordship, it has to be placed before Your Lordship, the written notes.
All right. Listed on 19th.
Yes. Yes.
Oh, blessed.
Item 91.
May I please, Your Lordship? Your Lordship had this case, my lord, earlier, and written notes of submission is already been submitted, my lord. In this case, my lord, in paragraph 3 of the writ appeal, my lord, the fact is stated.
Who's for the state here?
Yes,
I think there is also a Gram Panchayat.
Yes, my lord. I have filed the affidavit on 24th June. The Lordship has directed me to give the status of the rooms allotted. I have given the status and the resolutions. 24th June 2022. I had order dated 27th April 2022. Your Lordship has directed the district panchayat produce and file affidavit, if any, showing the factual position of the 3 resolutions and also the status of the occupants. That I have mentioned. Para 5.
Have you seen that affidavit?
My lord.
Do you have anything to say on that?
My lord, in this case, in the last occasion, my lord, the Honorable Court, my lord, directed what is the status of the
Correct.
Panchayat market complex.
Correct.
Because the respondents, my lord, denied that they are not in possession, and I have just repeatedly submitted that is the market complex is in the possession of the relief petitioners. And accordingly, my lord, so now government has filed that affidavit that yes, that read petitioners are in possession of the market complex. So whatever I am submitted, my lord, that was rightly submitted.
Oh, is that right?
Yes, my lord.
Where have they said that?
My lord?
Where have they said that the writ petitioners are in occupation of the market complex?
My lord, they have declared that, my lord.
Para 5. But the date on which you make this allotment, that's not in para 5.
Yes, madam.
Pursuant to the first resolution, the newly constructed rooms have been allotted. When was it allotted?
That is not mentioned.
My lord, in written submission of para 7, my lord, the lordship may have a glance, my lord, that the respondent number 2 to 11 submitted in para 4 of the writ petition that after the demolition of the Panchayat market complex due to the expansion of the state highway number 10 from Sundargarh to Sambalpur, the Kutra Gram Panchayat in its resolution dated 17th of January 2015 approved the proposal to provide the shop rooms respondent number 2 to 11, which was cancelled in GP resolution number 2 dated 2nd of October 2017. By page number 70 of Annexure 6 series of the counter affidavit, my lord.
When did they allot?
It was suppressed, my lord. They have suppressed the resolution, and on that basis,
dated 24 June 2022.
my lord, they have suppressed that.
1 minute, madam. We'll ask for an explanation. The affidavit dated 24 June 2022. In para 5 of the affidavit dated 24 June 2022, filed by the District Panchayat Officer Sundargarh, it is not stated that it is not stated when the newly constructed shop rooms were allotted in favor of the present occupants. Stop. It is also not clear how, despite the newly elected GP passing subsequent resolutions on 2nd October 2017 and 15th August 2018, differing from the resolution passed earlier on 17 January 2015, the later resolutions could be ignored. It says the shop rooms were already handed over and occupied.
Yes, my lord. That has been challenged, my lord. In paragraph 3 of the writ appeal, my lord.
All right. The exact dates of handing over the shop rooms to the occupants have to be indicated. And the relevant documents have to be placed on record with a supplementary affidavit to be filed before the next date. Based on 27th October.
My lord, blessed.
Item 92.
Can it be posted to October?
Yes.
No, we meet for 27th October.
October. It's okay. I'm sorry. I think I turned 7 September.
Weekly list item 92.
Oh, blessed.
The proxy counsel for petitioner in 92 appearing through VC.
Yes.
Sir, my submission is that the respondent has to submit their reply. Until today, we haven't received any reply from the respondents.
Yes,
and
Mr. Padi.
Yes,
already counter has been filed by the process of email e-filing. It was filed on 24th 9 2022.
The affidavit stated to be filed on 24th September 2022 be placed in record. Copy thereof is served on petitioner. How will you serve? You have an email. Does the petitioner have
already sent to the by mail email, my lord?
It has been sent to the petitioner by email. Is that right?
Lordship, I am the petitioner applicant in person.
Then who's this lawyer appearing on your behalf?
Sir, I am appearing from KK Singh Law Firm. KK sir is not in the condition to appear right now, so that's why he has asked
Whom
me
is he
to appear
appearing
as
for?
petitioner.
Lordship,
No, the petitioner is in person here before us.
I speak to KK Singh sir that government has not filed till date counter affidavit. What is
No, they've sent it to your email, he says. Mr. Party says
Yes, already
counter was sent to your email.
No, my lord. I am personally visited the office and
you check your email. Have you checked your email?
Yes, my lord. And last time entering into the courtroom, I checked my email.
You check your email again now.
Again, 1 second, I'll send you give the another number.
Lordship,
Whatever mail ID I have, on that mail ID I have sent it.
Lordship, I am going to their office and they can give me.
All right.
Collect a copy, I'll give a hard copy.
All right. Petitioner who appears in person will collect it in person from Mr. Party. The collect a copy of the counter affidavit in person from Mr. PK Party. Rejoinder that to be filed before the next date.
Lordship, I will.
Along with Mr. S.S. Kashyap, who is appearing, you will serve the copy.
11 January. All right.
Item number 93.
93 here, I filed
Item 93, Your Lordship. I'm filing a counter affidavit to the IA, Your Lordship. That has been filed.
Yes.
I'm serving a copy on the court.
I place the, my lord, the IA for vacation of the interim order.
Yes.
My lord, in this matter, my lord, the interim order has been passed. In a,
you do not want to examine this reply, sir?
My lord, that is a misdirected interim order. In fact, none of the case of the party is that the land has been purchased after the grant of compensation.
If you want us to record that you don't wish to file any rejoinder,
I'll file. My lord.
All right. Reply has been handed over. Just put down IA number 3112 of 2022. A reply has been handed over today in court on behalf of the appellant. Counsel for the applicant public respondents seeks time to respond to the said reply. List on.
I pray for a short date, my lord, because there is some environmental hazards which is occurring.
All right. 9th November. All right.
Obliged, Your Lordship.
November, my lord.
Interim
Can
to
it be
continue.
in October, my lord?
No, sir, please. Interim order. The same, whatever, interim order to
Interim order.
continue. All right.
Obliged.
Passed over matter. Item number 24.
Yes, madam. State is the appellant. Lordship may kindly have a glance. The lease was granted. The lessee did not comply the lease condition, did not deposit the ID cost, infrastructural development cost, as a result of which the lease was cancelled. After 24 years, the Honorable Single Judge has directed the state government to accept that amount, that is only 56,000, which was prevailing 24 years back, and give possession to the.
Who's appealing for the other side? Somebody must be appearing.
It is in the heart of the Bhubaneswar town, and
no, one HP Mahanti was appearing. Then appears for the respondent. Do you have fresh notice to issue or what? I think the legal heirs of respondent to be brought into record.
Legal heirs are already appeared. I think the same lawyer that your lordship see, but I
notice
think
without process fee be issued to HP Mahanti, the lawyer who appeared for the opposite respondents on April 2018. List on 18th January.
My lord, I will take notice on the new.
No, notice without process fee to that HP Mahanti. Let him appear on the next.
5th January.
18th
January. 18th January.
Passed over matter. Item number 79.
Item 79, JCLA 41 of 2011.
It's more than 11 years must be in jail. Which is the other passport? Now you carry on. We'll wait for that passport. Just send word from Mr. Sahu, Jagavan Sahu.
Item 94.
May I please, Your Lordship? Here, my lord, government has come up challenging an order of acquittal passed way back in the year 1994. The learned session judge, after elaborate discussion of the evidence of the prosecutions, have arrived at a conclusion that there is serious discrepancy between the evidence of PW 1 and 4, who are the star witnesses of the prosecution, along with other circumstantial evidences. But this honorable court, while reversing the order, though found there are discrepancy between the evidence of PW 1 and 4, but this is not so serious. The respondents were convicted. Then matter went to Supreme Court at the behest of my client. My client approached the Honorable Apex Court. Apex Court also remanded the matter. Therefore, this appeal has come. Before placing the judgment, I would like to draw attention to my written note of submission. I have prepared for your lordship's convenience.
Yes.
I have given your lordship kindly see.
Yeah. Yes.
This occurrence took place on 11/8/90 at 1:45 p.m. in the broad daylight. The place is near the Grand Road at Puri. Name of the informant is Vishwanath Panda, who happens to be the son of the one deceased. There are two deceased persons. One deceased is Narayana Panda and another is Kunna alias Kachinath Panda. Both are brother and father of the informant PW1. Charges are 302 and 34 of Indian Penal Code that the respondents on or about 11th day of August 1990 at about 1:45 p.m. at Grand Road, Puri town near Mausima Temple in furtherance of their common intention did commit murder by intentionally causing the death of the above-named accused persons. The fact of the prosecution's case is on 10/8/90, just before 1 day of the occurrence, the hawkership of the informant was allegedly terminated by the kerosene depot owner, namely Rampal Saha, and he was not issued kerosene oil. The motive is sought to be demonstrated as dispute between the informant and his family with the kerosene depot owners, with whom the accused persons had common intention. It is alleged that on 10/8/90, the respondent number 1 assaulted the informant Vishwanath Panda, younger brother Kashinath Panda, by inflicting a wound on the face of the latter, and later on in the day also the PW1 was also attacked. On 11/8/90, it was alleged that respondent number 1 along with 3 other persons who stood guard assaulted and killed the informant's younger brother and father Narayana Panda with a gupti. Subsequently, on the same day, FIR was filed against respondent number 1 and Buddha Puja Panda, respondent number 2, Kalia Panda is respondent number 4, and Sodangi, and one Kalusa. There are 5 accused persons named in the FIR. All the accused persons pleaded not guilty, but charge sheet was submitted accepting the excluding the Kalusaha, who happens to be the son of the grandson of the depot owner, Rampal Saha. He was not, the charge sheet was not filed against him. He was exonerated from charge, though FIR specifically says that at his instigation, these accused persons have committed the murder. There are altogether 14 accused, the witnesses examined at the behest of the prosecution, and there are only 2 eyewitnesses, that is PW 1 and 4. On 16/10/90, sorry, it is 93, I would have. 16/10/90, the line addition, sorry, 93. The line additional sessions of Puri, after weighing the evidence, acquitted all the accused persons, stating that the prosecution case did not inspire confidence, and there were material contradiction in the testimony of the informant. And on 12/1/94, an appeal was preferred before this honorable court, wherein division bench of this honorable court reversed the finding of the trial court and convicted all the respondents under section 302(34) of Indian Penal Code and sentenced them to undergo imprisonment for life on the testimony of the so-called eyewitnesses. 25/2009, the respondent on preferred an appeal before the apex court in criminal appeal number 2175 of 2009, wherein the honorable apex court was pleased to hold that the High Court has not dealt with the appeal in accordance with law, as the law mandatorily requires the appellate court to record reason, finding that the findings recorded by the court below were perverse and consequently remanded the case for fresh consideration. Hence this appeal. The trial court observation as to acquittal, as summed up, my lord, kindly have a glance. The trial court held prosecution version was not credible because the evidence as regards conspiracy / motive was found wanting. PW1 testimony was flawed by inconsistency of and remain uncorroborated, which was the substratum of the prosecution case. There was an apparent attempt on the part of PW1 to improve his case. Evidence of recovery of weapon is not credible. Medical evidence is not in consonance with earlier statement of PW1. Non-examination of witnesses in the vicinity of the incident. Presence of rigor mortis over the dead bodies of the deceased is absent, present, and non-production of bloodstain articles seized from the spot. Absence of injury on the face of the deceased allegedly caused on 10/8/90, and delay in examination of PW4. Admittedly, the PW4 was examined much after the date of occurrence. Though individually may not be vital, it is a finding of the trial court. When taken together, cumulatively leave grey spot on the suspicion in the prosecution's case. The suspicious features are so inextricably glued together that in the absence of independent and reliable corroboration, the evidence is not found to be safe enough to base the same for any finding against the accused persons who are entitled to the benefit of all reasonable doubts. And trial court observation is motive, my lord. I have next page. The motive behind the alleged murder was highlighted by the alleged incident dated 10/8/90, where it was contended that respondent number 1 caused a bleeding injury on the face of one of the deceased. However, the testimony of PW7 doctor showed that as per the postmortem report, no such injury existed on the deceased face. Hence, the assault by the respondent number 1 on 10/8/90 is not established. Prosecution has not even adduced any evidence to show any dispute between the informant and the accused persons. Prosecution had already given a clean sheet to the kerosene depot owners, at whose behest the alleged assault is purported to have taken place. Then recovery of the weapon, my lord, most important thing. While it was stated by PW14, IO that MO1 and MO2 were stained with blood, the chemical examination report exhibit 30 doesn't disclose that the blood were human blood. That is at page 26, para 13. Before taking to me, let me complete my notes. Discrepancy between FIR and PW1 statement. Name of the accused Robbie Behra does not find place in the FIR. Initially, Robbie Behra was not named. Some other person's name was there. And father name is different. His name is also different. And specific allegation was there. He also participated in the crime, in the affair. But subsequently, this Robbie Behra was inserted and Sodangi, whose name was there, he was eliminated. In the affair of the informant PW1 doesn't claim to have seen the assault. This is more important. In the affair, the informant PW1 doesn't claim to have seen the assault by any of the accused to the deceased Kasinath. But in his testimony before the court, he shows that he saw the respondent number 1 thrust a gupti into the abdomen of his brother. But all along he was claiming that I was holding a buzali. In the affair, the informant mentioned that respondent number 1 was holding a sar bhujali. But in his testimony for the first time in the court, he says that it was a gupti. The trial court found that it was not a mere omission, but evidence of PW7 explains the reason for change in the version of PW1. So PW1 has changed his version in the trial, my lord. In his statement, PW1 fails to talk about assault by accused Sodangi, whose name was initially there, on PW13. He is also a witness, injured witness, PW13. But he was turned hostile. But implicates Robbie Behra instead of Sodangi. Though Raghunath Pujabanda is mentioned in the affair a few times as in contact with PW1, later PW1 fails to recognize him and explain how his name came to be in the affair. It is his affair, my lord. He says it before the court. He doesn't know how his name reflected in the affair. His straightway said, I will bring to your lordship's notice about the evidence of PW1, where he denies about the involvement or the appearance of appearance of this Pujapanda in the affair. PW1 stated about the presence of Kalu Saha, Raghu Pujapanda, and one journalist with him at the time of occurrence. However, in court, he denied the presence of Raghu Pujapanda and the journalist. Trial court held that PW1 was not a reliable witness. Then unexamined witnesses, my lord. Though, as per affair, there are several witnesses to the occurrence, my lord. None of them have been examined. None of them, my lord. 7 except these two near relation, PW1 and 4. PW1 happens to be the son of the one deceased and brother of the other deceased. PW4 is the brother-in-law of the Narayan Ponda and the nephew of maternal uncle of the deceased Kasinath Ponda. They are all two interested witnesses or the related witness. None of the person whose name are suggested to be the witness to the occurrence as per affair are not examined in court. Discrepancy with PW4. Other eyewitnesses, he claims to be an eyewitness. He's a chance witness. He was roaming at that time in the street and he was searching for a rickshaw for pilgrim. They're all devotees of, they're all Sevaites of Lord Jagannath. Both accused and you also can see the discrepancy. Prior to his examination in court, the IO PW14 had not even found him to be a witness to the occurrence. PW4 has not disclosed his reason for non-appearance before the police for disclosing evidence. Trial court held that reason for delay of examination was too belated and disclosed at the time of trial only. In his statement before the police, PW4 had stated that respondent number 1 assaulted the deceased person by means of bhujali. This respondent, the PW4 says that the deceased was assaulted by means of a bhujali by the petition, by the respondent number 1. PW4 had not disclosed about the assault by accused Robbie with a Kazurian stick and by accused Kalia with iron rod. PW4 further omitted to state about the fact that his entry to the depot was prevented by the accused persons. PW4 also stated that Buddhaponda, respondent number 2, thrusted MO2 into the right side chest of the deceased, but his version was not supported by the medical reports. Trial court also found that his evidence that respondent number 1 was not assaulted, had not assaulted deceased, was directly contradictory to the statement of PW1, who stated that it was the respondent number 1 alone who inflicted the penetrating wounds. Thus, PW4's evidence did not corroborate PW1's evidence. Trial court held that PW4 tried in court to improvise on his omissions in the statement made to the police. The respondent number 1 points out the following suspicious circumstances in the prosecution's case, which runs as follows. Authenticity of the affair is the first, my lord. Plain paper affair was written. It is a 10 pages affair, my lord. Kindly appreciate. It is a 10 pages affair. And the occurrence took place at 1:45 p.m. and the dead bodies were carried to hospital at immediately thereafter. And they were declared dead in the hospital campus. And the informant person was recorded by the IO himself, my lord. Your lordship, kindly, the PW1 says his version regarding the occurrence, my lord, was recorded by the IO himself in the casualty, my lord. That the deceased were there in the, and subsequently at 2:20 p.m. this case was registered at Kumarpada PS. But it was not explained by the prosecution. The PW 14 in his deposition categorically stated this affair started to be recorded at 2:20 p.m. and concluded at 3:30. So, but much prior to 3:30, it was recorded as its own. On the Exhibit 16, Exhibit 1 is the formal affair which was drawn at the hospital on the basis of the statement of the PW1, and it was recorded by the IO himself, and it was subsequently sent to the nearest police station, that is Kumarpada PS, at 2:20 p.m. 2:20 is the time of registration of the affair. But the BW 14 in his evidence at para 19 has categorically stated that the affair was concluded, writing of affair was concluded at 3:30 p.m. So there is delay. So my contention, my respectful submission, it is an anti-time affair, my lord. Just to give color or to improvise their case or to insert some persons to be the eyewitness to the occurrence. And very next day, my lord, at 5:20 p.m., very next day, it was sent to the SDGM court. SDGM court is hardly 1 kilometer away from the hospital, my lord. It was sent to the magistrate on the very next day. Though law prescribes, it is to be stained forthwith, my lord. There is no absolute no explanation why it was sent on the 5:20 p.m. on the next day. My lord, the affair by Exhibit 16 shows that the same was registered at 2:20 p.m. and sent on the next day at 5:20 p.m. to the Learned Court of SDGM Puri. But the discrepancy in the timing of registration had not been explained by the prosecution. Therefore, respondent number 1 submits that such anti-timing of affair was made to introduce eyewitnesses to support the prosecution's case. In support of this, the respondent relies on the decision reported in 94 SCW, page 2210. Motive of the alleged murder of the accused persons, paragraph 11 at running page 23, prosecution seeks to establish that termination of the hawkership of PW1 led to certain trouble between the informant party and accused Munakara. Further case of the prosecution that the kerosene depot owners were the brain behind the crime. Police has not found any prima facie material against Kalusa, grandson depot owner, for which he was not sent up for the trial. But in the affair, he has stated that he is having criminal background, and at his instigation, these accused persons have committed the murder. PW1 and PW9 allege that Munakara accused respondent number 1 caused bleeding injury on the face of the deceased Kasinath on 10/8/90, previous day of occurrence. But PW7 doctor who conducted postmortem of Kasinath Panda on 11/8/90 and furnished report exhibit 8 doesn't disclose any old injury on the face of the deceased Kasinath Panda. Even if allegation of PW1 and 9 to the effect that there was a dispute between accused Munakara and informant and his family are said to be true, but the prosecution has not adduced any evidence to show any dispute between the informant and his family members with the accused persons. Therefore, the motive for alleged murder is no way connected to the accused persons. Moreover, the prosecution has already given a clean sheet to the kerosene depot owners. The inquest was held. Your lordship can see the inquest that inquest part, my lord, immediately after registration, inquest was carried on. Inquest and dead body challenge was prepared. But in both these two important documents, nowhere it reflects the name of the accused persons or how it has happened or what are the weapons used, who are there in presence. Nothing was stated, my lord. If your lordship see that LCR has not come, my lord. But though I tried to get it, it was not there. Even in your lordship's court, it is not there. LCR has not come. So I have no occasion to see examine these exhibits. Exhibit 9, 10 and 19, the most important exhibits. The inquest was held and dead body challenge was prepared on 11/8/2022 in presence. Sorry, 19. The date is wrong. In presence of the informant, but the name of the accused persons and weapon of the offense were not described. PW 14 had specifically stated that immediately on registration of the case, he had examined the PW 1. So, my respectful submission, the PW 14, who is the IO, he is very much aware before inquest was carried on, who are the assailants. Because PW 1 himself admits that immediately after registration, he was examined by the police. And the IO also directly said, my lord, that immediately after registration, he examined the inquest, he has examined the PW 1. So, non-mentioning the name of the accused persons is unnatural, my lord. It's not, the prosecution case should create a suspicion in the mind of the court that why such two important documents were subsequently inserted in the prosecution's case. Recovery of weapon, that is paragraph 13 at running page 26 to 28. PW 14 IO in para 10, running page so-and-so, has stated that on 14/8/90, he arrested Kalia at 10 a.m. from Vajraghara Amin Jaga of Dolamundapa Sai, Puri. This is the area, my lord. I belong to that area, so I know. This is a gymnasium, my lord. They used to keep all lethal weapons for the purpose of their practice, my lord. And it was these two weapons, alleged weapons, were kept in Almira, inside the Almira, and it was sealed, my lord. It was locked. And the IO himself broke up in the lock and recovered this weapon, my lord. There is no material that these locks were seized or lock, it was kept in lock, save and except the oral statement of the PW1 before the court. He has not stated, he has not taken any steps to seize this lock from the Almira, from where both the weapon of the offense were recovered. In para 10 of running page 244, has stated that on 14/8/90, he arrested Kalia at 10 a.m. from Vajraghar Amin Jaga at Dolamundapa Sahi. Kalia led him to Vajraghar Jaga along with two witnesses, where PW4 recovered one blood-stained Bhujali MO2 and one small Gupti MO1. Exhibit 10 is the seizure list. You'll also kindly see the seizure list, Exhibit 10. That is more important. What information he gathered, what prompted him to lead the accused to recover those weapons, it must be on the records. For a better appreciation, my lord, you'll also kindly see Exhibit 10. I couldn't find, my lord. It is not neither with me nor with the court. And one recovered one old blood-stained Bhujali MO2 and one small Gupti MO1. Exhibit 10, seizure list, shows that 4 persons were the witnesses to such recovery of weapon. Out of the 4, only 2 were examined as PW8 and PW10, but both of them were declared as hostile. Except PW14 IO, there is no evidence and record to show that accused Kalia, while in custody, led to the recovery of the weapon, and his exact information was not reduced in writing. Though it was stated that MO1 and 2 were stained with blood, but the chemical examination report, Exhibit 30, doesn't disclose that blood stain were human blood. This is the most important. You will also kindly take note of this. These 2 weapons, though it was recovered, my lord, the requirement of seizure, my lord, or the requirement of recovery of those or discovery of these weapons were not carried on, were not followed the IO, because there is no statement of the accused persons under Section 27 of the Evidence Act. Thus, evidence as regards the recovery of MO1 and MO2 falls short of standard of proof to accept the same under Section 27 of the Evidence Act. In support of the above finding, the respondent relies on the judgment reported in year 2019 Supreme Court 3714, which directly answers the issue, my lord. If it doesn't contain the serological, the report says, chemical examination report, that the blood is there, but it is not human blood. They don't find it is a human blood. So that creates a suspicion in the mind of the court, my lord, for which they were acquitted. Ocular account of paragraph number 14, my lord, for which such purposes the evidence of PW1 and 4 were confronted to the court PW1. The informant is the son and the brother of the deceased. PW4 is the maternal uncle of PW1. PW1 in his evidence at running page 106 stated that Kalu Saha was all along present during the occurrence. But Kalu Saha has not been examined. Kalu Saha's name appeared in the affair as accused. He has not been named as a witness. PW1 at paragraph 20 of his evidence stated that Munna Kara gave one thrust with MO1 Gupti into the chest of his father and further stated that no accused other than Munna assaulted his father. PW4 just give a conflicting version. PW1's evidence to be assessed against the affair at Exhibit 1. According to PW1, Exhibit 1 was scribed by PW14 IO, while PW14 states that a copy of Exhibit 1 was given to PW1. But on the contrary, PW1 states that he is unable to recollect whether the copy of Exhibit 1 was supplied to him. Interestingly, PW1 states that signature appearing on Exhibit 1 was obtained by police from his house. All along, my lord, from the time of occurrence till the cremation of the bodies, this PW1 had taken active participation throughout the investigation, my lord. But he says that his signature in the affair was obtained from his house. So obviously that presupposes, my lord, it was obtained, this affair was much after written in the house of the PW1 on very next day. Because at 4 o'clock, they completed the cremation. The evidence is there. PW1 states that the signature appearing in Exhibit 1 was obtained by police from his office, from his house. When Exhibit 1 was in the house, the PW1 during investigation, it has to be carefully scrutinized. In the affair, PW1 has stated that when he was going into the office of Kalu Saha, he had seen one Patanjali coming out of the place. Office means that place of occurrence. Kalu Saha, Raghu Pujaponda and another journalist were discussing when deceased Kasinatha soaked in blood entered into the office. The said Kalu Saha, Raghu Pujaponda and another journalist have not been examined and the reasons remain unexplained. PW1 has stated that he saw one Sodangi belonging to Matimondo Sai holding an iron rod. And FIR says that Sodangi happens to be the son of a stamp vendor, Milord. But subsequently, another person was identified in TI parade who happens to be belongs to different Sahi, and his father is a betel shop owner. This is the prosecution's story, Milord. The informant in the FIR stated that he could identify Sodangi PW1 in the FIR. He doesn't claim to have seen any assault by any of the accused persons on his deceased brother Kasinath Panda. But in his evidence, he stated that Munakara thrusting a gupti into the abdomen of his brother Kasinath Panda. Though the name of Raghunath Panda appears from more than once in the affair to have come in contact with PW1 on the date of occurrence, but PW1 fails to recognize such a person and is incapable to explain how his name appeared in the affair. This is more very shocking, Milord. A person who gives a 10 pages affair and categorically naming the persons who are involved in the crime and subsequently turn around and say, I don't know who are they. That shows, my lord, he is not the author of the affair. Somebody has written the affair, but probably the IO has written the affair after getting some information here and there. Contradiction or misdescription with respect to the weapon of the assault.
That you have already read, sir.
Which one, my lord?
One person said Gupti, the other said Bujari.
Yes, my lord, that contradiction with regard to PW1 and 4, my lord, I want to point out, my lord. PW1.
Yeah, you already pointed that out, sir, earlier. This you're repeating. This one person said Gupti, the other said Bujali.
Yes.
You've already mentioned it in the earlier pages.
Earlier pages.
This you're repeating it here.
Discrepancy, the evidence of PW1 and 4 I have not stated. I would like to draw my lord's attention. PW1 has specifically stated in the affair that I was holding a Buzali, but in the court he has stated I have assaulted by means of a Buzali to both father and son. But affair says only I have assaulted to father by means of a Gupti, by means of a Buzali. But PW4, who is claiming to another eyewitness to the occurrence, he says that I have not assaulted the Narayana Puja Panda, who is the father of the PW1. He says that only Munna Panda, para 18 of his evidence. I will come to that. Your Lordship, kindly allow me to place in my own way.
We won't ask you any questions, sir. Sorry, we withdraw the question. You carry on. You carry on. All right.
I mean, no
problem. You read, sir. Judges are supposed to keep completely silent.
Double murder, my lord. We
will keep completely silent, sir. We will keep completely silent.
That will.
Yes, it will help you, sir. Please.
That will not help.
Sorry to have asked you a question. Sorry. Yes.
A contradiction of mistakes with respect to the weapon of assault. PW1 for the first time in the court states that Munakara used Gupti in assaulting the deceased. Earlier, he had said that Munakara used Bhujali in assaulting the deceased. Running page 68 FIR says that Munakara was holding a Bhujali. Running page 69 says that Munakara thrust a Bhujali into his deceased father. Running page so says that he saw Munakara thrusting a Gupti in the abdomen of his brother, Milord. Munakara assaulted his father and brother with MO1 Gupti, but not with MO2. The distinction between MO1 and MO2 can be found in Exhibit 9, report of PW7. In Exhibit 9, it was specifically stated that penetrating injury found in the bodies of the deceased was definitely caused by Gupti MO1. Further, Exhibit 9 reveals that the death is not possible by Bhujali MO2. PW7 in his statement has categorically stated at running page 131, 33, and 34. MO2 is never called as Gupti. He further stated that the wound are never possible by MO2, Bhujali. Therefore, the evidence of PW7 explains the reason of change of version of PW1 statement with regard to the weapon. Such contradiction could not be explained by the prosecution. PW4, uncle of the petitioner PW1 and an eyewitness to the occurrence, has not stated before the police that Munakara assaulted both the deceased by means of a Gupti, but had stated that Munakara assaulted both the deceased by means of a Bhujali. In para 17 of the PW4 statement, he stated that Buddha Panda thrusted MO2 into the right side chest of the Kasinath Panda, and the allegation of thrusting MO2 is not supported by medical evidence. Non-corroboration of PW4, running page 44, PW4, is the uncle of the PW1. His presence at the spot at the time of occurrence was on his way to call a rickshaw for a pilgrim is highly doubtful. He is a chance witness. PW4 states he was present at the time of only 2-3 pages. Kindly bear with me. He was present at the time of occurrence at the hospital and also at the funeral grounds till 1 a.m., but he was not examined by the police till 13/8/19. But the evidence says, my lord, PW14's evidence, that these accused persons were arrested on 19th. Occurrence took place on 11th. Kalia was arrested on 14th. We were arrested on 19th. But specifically was asked in my remand report, name of PW4 was not appearing. So his name was not, he was never examined till 19th. Though prosecutions come forward with the case that he was examined on 13th, but cross-examination of the IO says that he was arrested, though arrested on these respondents were arrested on 19th, and he has also admitted that till 19th in the forwarding report he had not stated about the eyewitness of PW4. So these are all creating stories and developed time to time. The reason for delay in examination as PW4 is that on the night after occurrence he had to leave for Raulkela to inform about the incident to one Lakshmindra Panda, whose marriage was settled up with daughter of deceased Narayana, And only after his return, he had a talk with PW1, and PW4 told PW1 that the person whom PW1 described as Sarangi is in fact Robbie Behra. There is delay in examination of eyewitnesses. Although PW4 is a witness to the occurrence, but prior to the examination of PW4, the IO had not found that PW4 is a witness to the occurrence. PW4 in paragraph 14 of his statement states that he had not stated about his visit to Raulkela before the IO. Thus, the reason for delay of examination of PW4 is too belated and is disclosed at the time of the trial only. PW14 in his cross-examination has categorically admitted that the accused respondent number 1 and 2 were arrested on 18/8/90 and forwarded on 19th. But in the forwarding report Exhibit C, you'll also can see the Exhibit C where the name of PW4 is appearing or not. It was not stated that PW4 is an occurrence witness. PW4 in his statement states that Kalia Ponda was holding an iron rod, Buddha Ponda was holding a gupti, Robbie Behra was carrying a piece of Kazurian log, Munna Karo was carrying some weapon which were concealed. PW4 further says that Buddha Ponda thrusted a gupti into the chest of Kasinath. Robbie assaulted deceased Kasinath on the head by means of log. Kalia dealt a blow by means of an iron rod on face of the Kasinath. He further stated that Kasinath ran towards the office room, shouting that he was being killed. Munna chased him, thrusted a gupti in his abdomen in front of the office. This story was developed at the time of trial by PW1. But if your lordship correlate the evidence of PW14, PW14 has made a spot map. He was categorically asked whether from place of occurrence to the office room, it was visible or not. Because the PW1 consistently says that while he was discussing this matter with the depot owners and other journalists and other persons, he heard that one of the deceased, Kasinath, ran after having assaulted. So he had not seen that who had assaulted the deceased Kasinath. But that spot map and the evidence of PW14 will show that this place where the PW1 was standing, alleged to have stood, my lord, it was not visible to the place of occurrence. So his statement that's why the trial court has said that he is not reliable. Right side of the chest, Kasinath Panda, and the allegation of thrusting MO2 is not supported by medical version. In para 18, he states that Buddha Ponda thrusted MO2. This is more important, my lord. PW says Buddha Ponda, one part is, my lord, discrepancy in the weapon of the offense. But how can such a discrepancy, when a person who was not assaulted, he has been implicated in the trial, my lord. He states that Buddha Ponda thrusted MO2 into the right side chest of the Kasinath Ponda and into the abdomen Narayana Ponda below the chest of PW7 medical examiner. In this, his statement at paragraph 25 stated that the incised wound and the penetrating wound on both the deceased are not possible by MO2. MO2 is the Bhujali, my lord. In para 18, PW4 had stated that Munna has not assaulted Narayana Ponda. That is directly contradictory to the evidence of PW1, who states that it was caused Munna Karo alone who inflicted the penetrating wound on the deceased persons. Hence, the evidence of PW4 doesn't corroborate the evidence of PW1. Allegations against Kalia Ponda, from whom the weapon of the offense received. In the FIR at running page 68, the informant stated that Kalia Ponda was holding a knife. He further stated that this knife was never seized, my lord. He further stated that he had seen blood on the weapon of the Kalia Ponda and other accused. PW1 at running page number so-and-so had stated that the other three accused persons, namely Buddha Ponda, Kalia Ponda, and Robbie Behra, were brandishing their respective weapons standing near the gate of the depot. In his evidence, PW4 at running page number 118 stated that Kalia Ponda was holding an iron rod. But in the evidence, PW4 at running page 118 states that Kalia dealt a blow on the face of the Kasinath with iron rod, which he was holding. PW7 at running page, Dr. Miller at running page 134 at page 30 has only stated that deceased Kasinath Ponda had two injuries, one on the abdomen below the rib of the left side, and other one is the second intercostal spare that is between the second and third ribs on the left side of the chest. Respondent, in support of his contention, relies on the decisions reported in 2011 Supreme Court. First, my lord, I would like to draw your lordship attention to the decision reported in 1994 at CW 2210, which says about the anti-timing of the affair. There is evidence showed that none of the alleged eyewitnesses had actually seen the occurrence, like our case, my lord. They were introduced as eyewitnesses after thoughtful deliberation and consultation. Authenticity of the affair was lost, being anti-timed, had not been recorded till inquest proceedings were over at spot. Anti-timing of the affair was obviously made to introduce the eyewitness to support prosecution's case. No evidence led to show as to when copy of the affair special report was actually dispatched to magistrate. Alleged ocular testimony was contradicted by the medical evidence. Failure of prosecution to prove guilty beyond reasonable doubt. Accused entitled to benefit of doubt, and they were, though convicted by the Allahabad High Court, it was reversed by the Honorable Apex Court. My lord, second judgment with regard to my lord, that discrepancy in the weapon of the offense, my lord. Accused persons armed with lathi and tabla assaulting deceased resulting into his death. Delay of 8 days in recording statement of the alleged eyewitness, though they were present in the village and police were knowing that these witnesses were alleged eyewitness to the incident. Plea that witnesses were scared to one of the accused cannot be accepted, since even at the time of recording that statement after 8 days, accused was not arrested. Presence of eyewitness at the spot of incident not established. Recovery of the weapon not helpful, as because the blood on them was not proved to be the human blood or that of blood of the deceased. FSL report proving that blood stain were disintegrated and their origin was not be determined. Accused liable to be acquitted, my lord. Here it is our case, my lord, exhibit 10. The weapon of the offence was though sent for. It was kept inside a almirah in a cover, my lord. That cover of the weapons were not sent to the chemical examination, my lord. There is no reason assigned whatsoever why it was withheld. And it is also not stated in the prosecution's case, my lord, why, my lord, the other witnesses, those who were present at the time of occurrence, they are not examined immediately on the date of occurrence, my lord. I also noted in my this 2009 Supreme Court AR 3714 relating to blood stain, my lord. Other is, my lord, that is 98 Criminal Law Journal 2277. Evidence of eyewitness that he saw assault made on deceased when he was accompanying him. Conduct of eyewitness in not informing anyone and disappearing till next day evening, found inconsistent with the act of accompanying deceased. Fact of his having seen the incident highly doubtful. Besides, person filing FIR as per his own saying, claiming certain statement in FIR to be incorrect. Time of recording FIR also found doubtful. Moreover, recovery of weapon of offense also found unreliable, since it was uncorroborated by independent witness evidence. Here also not a single seizure witness come forward to support the prosecution's case, my lord. Another, my lord, that is 2011 Supreme Court page 2302. Improvement and contradictions, my lord. Marginal variation in statement of witness cannot be dubbed as improvement, but minor contradiction, inconsistencies on trivial matters do not erode credibility of witness. However, omission in material particulars affecting core of the prosecution case discredit the testimony of the witnesses, my lord. That all these evidence judgment I have given, my lord, I am not wasting your lordship's time, but I would like to draw my lord's attention to the paragraph 14 of the judgment. And what he has not only seen the, my lord, there is discrepancy about the weapon of the offense. He has found, my lord, with great respect. Subsequently, my lord's the sessions has also elevated to this court. He has elaborately discussed the judgment. I would like to draw your lordship attention to some of the paragraph. Of course, my learned friend has placed vividly paragraph 14, your lordship, in this. Why it was displayed? What is the reason behind it? Para 14 kindly have a glance at page. At page 28, you'll also kindly see. May I read, Miller? Now coming to the most important aspect of the case, that is the ocular account of the same. The court is confronted with so and so evidence of PW1 and 4. PW1 is the son and the son of the deceased, and Narayana is the father of the informant. PW4, Shamsundar Panda is the brother-in-law of the deceased Narayana Panda and is the maternal uncle of informant. PW1 in his evidence states that on 11/8/90, being summoned by Kalu Saha through his Himachal Patra, PW5, the deceased Narayana Panda went to the kerosene depot and returned. Thereafter, the PW1, the two deceased persons, and PW5 went to the kerosene depot at about 1:30 p.m. At the depot, my lord, the two deceased persons waited near the gate, and PW1 alone went inside and met Kalusa. Now, here they have stated that there is an iron gate, big iron gate, and near the iron gate there is a beetle shop, where these two deceased first waited there, my lord. The PW1 went inside to the office while he was discussing, my lord, while he was discussing with the other.
Sir, if you're reading, kindly read. If you're commenting, you comment. You were reading and you have stopped reading, sir. Kindly complete reading.
Okay. At about 1:30 p.m. at the depot, two deceased persons waited near the gate, and PW1 alone went inside and met Kalusa. Seeing the PW1, Kalusa denied to have sent for him. When PW1 was there, he heard the voice of deceased Kasinath coming from outside, that he was being killed. PW1 started towards the gate. But at the door of the Kalusa's room, he saw that accused person's Kara thrusted a gupti into the abdomen of his brother, Kasinath, who escaped into the room and fell down unconscious. The deceased Narayana Panda came running to the door of the aforesaid room, crying for help. Accused Munakara, who had chased the deceased Kasinath up to the room, thrusted his gupti into the Narayana Panda chest. PW1 also saw the other three accused persons were brandishing their respective weapons near the gate of the depot in order to prevent the entry of the outsider. Accused Buddha Panda was holding a big gupti. Accused Kalia Panda was holding a knife, and accused Ravi Bera was holding an iron rod. Deceased narrator fell down unconscious inside the room. Out of fear towards the accused persons, PW1 bolted the door of the room from inside, where deceased persons were lying in pool of bloods, and Kalusa was also present. After some times, when the accused persons had left, outsiders came and asked PW1 to open the door. Thereafter, PW1 carried the deceased persons to the district headquarters hospital, Puri, where on examination by the doctor, the deceased and persons were declared dead. After some time, PW14, the IO arrived at the hospital, and PW1 narrated the incident to the PW14, who reduced the information into writing, which is the FIR Exhibit 1.
Yes. Now tell us what you read this whole paragraph to say what?
Then next paragraph. It is to be read conjointly. Both
all right, read the next paragraph. All right.
Though in the evidence of PW1, it is asserted that one Kalusa was all along present during the occurrence, he was not examined as a witness in this case. Kalusa's name appeared as an accused in affair. Kalusa is not also cited as a witness in the charge sheet. In this cross-examination at para 20, PW1 specifically states that accused Munakara gave one thrust with MO1 into the chest of his father, and that no accused other than Munna assaulted.
Anyway, sir, all this you have dealt with in your note. We just read that entire note.
But with regard to Milord, anti-date Milord, that is...
we will go through it, sir. You can be assured we will go through the judgment.
PW14 evidence, only I will place one evidence of PW14. Is the IO...
So you can be assured we will read every page, every letter, every word, every judgment. You can be assured of that, sir. All right.
But only Milord, I will ask three paragraphs of that judgment, Milord. the scope of interference in the appeal.
Yes, yes, yes.
I will.
Yes, all right.
My lord,
It's a very comprehensive note.
my lord, I'm appearing for
Yes.
respondent number 3 in this petition. I have also furnished a note, my lord. I'll not repeat what my learned senior has said because he has dealt with everything, my lord. Only I'll submit one thing, my lord. Scope of 378, your lordship,
Is very limited.
Is
Correct.
very limited. Double
Correct.
presumption lies in favor of the accused.
You're
In
right.
this case, admittedly, there have been contradictions. And all the findings given by the learned trial court is based on scrutinization of evidence. And he has tried every possible way to find out the prosecution's case, how it stands. But he failed to get anything to support the prosecution's case. I have elaborated everything in parawise, my lord. I'll not submit further.
All right. You also file a note in reply to
My
this.
own position is, my lord, your lordship will only bear it in mind that this is an incident which took place within 5 to 6 minutes.
All right.
So these minor discrepancies that I am submitting, my lord, it is very evident and natural that eyewitnesses can also go wrong at times in when saying incident ghastly murder like this.
All
So it is only an incident that is there in the cross-examination of the PW1 that it is an incident of 5 to 6 minutes.
All right.
I'll also give a...
All right.
Also, the citations are in the note, man.
All right. Orders reserved. You say it will be open to the counsel for the parties to submit further written notes of arguments within 1 week. All right.
Obliged.